hold on just a moment for us. We need to do something with Jax. I'm so sorry.
Yeah, I'll wait. No, see, he took off? Oh, okay. We find out if Lucas is in lockup and he needs more time.
Okay. Does he need more time?
I'll give him whatever time he needs.
We will give him more time if he needs it.
I didn't know it was off.
Okay. Okay. Okay, thank you. Yes, please stay tuned. Thank you. Lucas is coming.
Oh, he's coming. Okay. Oh, there he is. Did you need more time, sir?
No, I just was speaking with him.
Okay.
Just wasn't sure when you're coming out. He was still waiting in the room.
Okay. We're good though, because the system,
Yes, 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 yes.
we know what the problem was this morning.
Yes. I don't.
No, I'm not ready for you this morning. I'm done. I'm so done. No, I'm done. I'm done. I'm just. You're doing. What are you doing?
Do I needed to do over?
I know. You need to go over there, call them, get him out, and then you have a seat. And because between you and Alan, I'm on my own. And we know how well that works out. Just gonna make my own decisions.
Okay, now we're ready for this. Thank you.
Okay, go have a seat. Think about what you've done. Mr. Duke, as an honor of you, we were all going to put on big ears, but we just didn't.
Big ears. No.
I was going to put on big ears, come out talking in a high pitched voice. No. No. Well, Alan will. That would be funny. Court does call the case of the people of the state of Michigan versus Larry.
Good morning, Your Honor. Mary Townhouse, Assistant Prosecuting Attorney, and the people.
Good morning, Your Honor. Edward Dukes on behalf of Larry Lee.
All right. Date and time set for a preliminary examination. Are we ready to proceed?
People are, Your Honor.
We are as well.
All right, very good.
Your Honor, people call Stephen Bosley. Stephen.
Please come forward and be sworn.
Ready to take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you about to give the truth, the whole truth, and nothing but the truth, so you got? Yes. Please spell your first and last name for the record, please. Stephen Bosley. STD9KWASNY.
All right, very good. You may inquire.
Thank you, Your Honor. And I want to make sure I'm saying that last name right, because I think I've mispronounced it a few times. Is it Quasney? Okay. Mr. Quasney, could you please tell the court where you lived in 2018?
914 Judy.
Okay. As far as you know, is that city of Ann Arbor, state of Michigan, and Washtenaw County?
Yes.
Thank you. And in early, excuse me, 2024, around January, February, did you walk into Ann Arbor Police Department station to report a crime?
Yes.
Okay. And did that crime that you're reporting involve a Larry Lee?
Yes.
Do you see Mr. Lee in the courtroom today?
I do.
Could you please point him out, describe something he's wearing? Could you describe what he's wearing?
A jail outfit.
Thank you.
Hold on one moment, Ms. Tanner. The two people in the front row, you need to back up one row, both of you. Excuse me. Yes, you guys just need to back up one row. All right, just that first row needs to be empty. Thank you.
Your Honor, may the record reflect the victim identified the defendant, pointed him out in the courtroom at defense counsel's table.
Without objection, record shall so reflect.
Objection.
Thank you, Your Honor. And what you reported, where did that take place?
Went home.
At that Dewey Street address you just mentioned?
Yes.
Okay. And can you please tell the court what you reported happened? When you say he, who are you referring to?
Larry.
Mr. Lee, defendant?
Yes.
Thank you. I'm sorry, I just have to be really clear for the record.
Yeah.
That's why I keep asking you questions. I'm going to ask you some questions about what happened and what you reported. When I'm done asking questions, defense counsel might ask you questions, okay? If you need either one of us to rephrase anything, please let us know, okay? And you said you reported something that happened in 2018. Do you remember approximately when during that year it happened? Okay. And who was in your apartment when this crime happened?
Just there.
Okay. Can you tell us what had happened earlier in the evening? At what point did you get to your apartment?
So, I had people come over from after bars one night. Never met Larry before. He came with another friend I had. I don't remember who she was, but it was another girl. Came to drink at my place. He asked kindly to stay over because, well, everyone started to leave. It was done the night. He asked to stay over because he was too drunk to drive, so I let him stay over. And,
I want to just pause you there. So he asked to stay over because he had been drinking.
yes,
You let him stay over. At that point, had he done anything to make you feel like that would be a concern of yours for him
No.
to stay over? Okay. Good. Well, go ahead. What happened after you allowed him to stay over?
so I fall asleep. I wake up to him in my bed, buck ass naked, stick out.
Okay. I'm going to go back a little bit and then we'll get to the details, okay?
Of course,
Before you went to bed, you indicated he was staying at your place. Where was he supposed to be sleeping?
on the couch.
Okay. Before you went into your bedroom, was he on the couch?
Yes,
Okay. And had you indicated, excuse me, had you indicated to him that that's where he was going to be sleeping?
yes.
Do you remember approximately what time it was? Was it early, late?
6, 7.
Okay. And had everybody been at your house and kind of drinking and just spending time until then?
Yes,
So he's on the couch, you're going to bed at that point in your bedroom?
Yeah.
Thank you. Had you, can you describe just to the court very briefly the layout? So where's the living room in relation to the front door and where's your bedroom?
they're pretty close. It's not a very close.
So you went to your bedroom, were you starting to get ready for bed or were you already in bed when Mr. Lee entered?
Silence.
And what's the first thing you noticed?
His dick was out
Okay. Were you awake? How did you wake up before you saw that?
abruptly.
Okay. So you're sleeping in your bed and I'm going to ask you to be a little more detailed if you can. You're sleeping in your bed. What's the next thing that happens that you remember? And did that wake you up? His presence? Okay. And when you wake up and you open your eyes, what did you see?
Yeah.
Mr. Lee, is that who you're referring to?
Yes,
Okay. And if you remember, did he have any clothes on?
no,
No clothes on at all?
I mean, like the shirt was kind of off, his pants were down, like they were like around like his like knees or something.
Okay.
So,
Were you wearing any clothing in bed?
yes,
And so you wake up, you see Mr. Lee, and you said his penis was exposed.
yes.
Do you remember if he was doing anything with his penis?
And like at that moment, I was kind of scared for my life. It's the first night I ever met him. And, you know, it's not a fun situation to wake up to.
What happened next? So you wake up, you see Mr. Lee, his penis is out. What happened next?
I accidentally get the fuck out of my house.
Okay. Did Mr. Lee get closer to you or do anything to your body?
He was resisting.
Okay, can you tell the court a little bit more about that,
So he
please?
was trying to talk about pants, saying it'd be okay. Don't have to tell anyone. And then I just kept yelling, screaming. It was waking up at the time.
So at this point, because you saw, when you saw Mr. Lee, I want to go back a little bit. When you saw Mr. Lee, how far was he from your bed?
He was in my bed.
He was in your bed already. Okay. And then what's the next thing he did? You said he tugged at your pants?
Yeah,
Okay. As he's tugging at your pants, is that when you were telling him to get out and yelling?
yes,
And what was he able to move your pants down?
no,
Were you fighting him?
of course.
Do you remember, or were you laying on your stomach, back, or side?
I'm on my stomach.
So as he's tugging at your pants, where on your body? I know this is, silly question because we know where pants are, but where on your body is he touching as he's pulling?
My hips.
When you screamed at him to get out of your apartment, did he leave right away?
He resisted.
Did anything happen after he was tugging at your pants to pull them down?
No,
And you said he was saying some things to you.
yeah, just let it happen. It's okay. Won't to tell anyone.
And what in your mind did you believe that to mean? Just let it happen. Let what happen?
Like, to try to sleep with me.
Was his penis out during all of
Yes,
this whole interaction? Did he eventually leave?
eventually.
Do you remember approximately how long it took for him to leave?
5-10 minutes.
Can I have a moment, Your Honor?
Yes.
What was going through your mind as Mr. Lee was tugging at your pants with his penis out?
I was scared for my life. Never met him before that night. Didn't know who he was. Just in my bed doing that. Never experienced anything like that in my life before.
What was going through your mind once he left your apartment?
How that could have happened? Because the situation goes from trying to do him a favor, not like trying to drunk or anything like that, to now he's ass fucking naked in my bed.
Can I ask you to try not to cuss in the courtroom? I know you're upset, but we're gonna try to be as polite as we can, okay? Did you think about reporting the incident?
I wish I would have. But no,
Can you tell the court a little bit about what was going through your head that you didn't at the time?
like, you usually don't talk about, like, if something like that happens, it's hard to talk about. It is.
I don't want you to go to any details, so just yes or no answer. Did you end up running into Mr. Lee later on in 2023,
Yes,
December of 2023, roughly?
yes,
Again, same thing. I don't want you to go into any details, just yes or no. Did you end up running into Mr. Lee sometime in January of 2024?
yes,
Without going into what you've said, have you talked to other people about this since 2018?
absolutely.
And has that had an effect on how you feel or how you felt about reporting it?
Yes.
Okay. Again, without going into what anyone said, can you tell us a little bit more about that? Sure. Can you tell us kind of what your mindset was and why your mindset changed?
Once I learned that he's done this to others and it's continued paying for it, I mean, I just started saying something. Because he has a long history of harming others.
One moment, Your Honor.
Yes.
No further questions at this point, Your Honor. Thank you.
Cross-examination.
Good morning. I'm going to ask you a series of questions. If you could just sort of follow along and answer them as they come at you. This was an event that was reported to the police initially in 2024.
Yes.
And this was an event that occurred that you're testifying to back in 2018. And in 2018, you did not go to the police. In 2018, you testified that he came to your residence. That's correct. And do you know who he came with? How many people came to your house that evening?
There was 4 total counting.
Who were the other individuals?
Can't remember the other.
Who did what you said you were at a bar. What bar were you at?
What's important is
No, I'm just,
The answer.
if you could answer my questions.
he didn't come to us from the bar, he joined through.
Okay,
So
fair enough.
So you were at a bar. Which bar were you at? And what day of the week was this? It wasn't during the week? You said a second ago, he came with somebody else. He didn't come directly from live.
Some other girl.
How did that other girl that we don't know to come over to your house?
She came with the other person. I was kind of fuzzy. It's like when you go through a traumatic experience like that, you kind of.
Now, you just got to say what you remember. So this other girl had been in contact with you to come over to your house, or was it that other girl through somebody else? Okay, so you said there were 4 total. Was that including you?
Yes.
Okay, so you invited one person. How many people did you actually invite over? And 4 came. 3 came. Did they all come in your apartment together? Do you know if they separate times who came first? And then who came second?
If I knew where they were at, it has to be in this room for how many times.
Okay, so you just brought up another buddy. You said there were 4 people there. How many people were over there?
4.
Okay. So you said they came together, or they came at separate times? Okay,
Came together with another girl. I knew the girl's name. I remember the girl's name.
okay, so he comes with somebody else. When did somebody else come? Okay, is that something you remember or you're just trying to put together today?
No, this is something I remember.
Okay. About what time did they come to your residence?
32:30 somewhere.
What was the intention of all these people coming to your house at 2:30 in the morning?
So
I'm gonna object, Tony. He can't speak to what their intention was. He can only speak to what he.
I'll sustain the objection. You need to rephrase your question.
Okay. You were invited people over. What did you plan on doing with all these people? Okay, was there alcohol involved?
Yeah.
Okay. Had you been drinking at the bar? Okay, about how much did you had to drink that evening? And what were you drinking? Okay. What time did you get to the bar that day? And you were there till close?
Yeah.
What time did they close? Don't close at 3 or 4? Close at 2? Okay, so how well do you, outside of this defendant, how well do you know the other two people that were with you?
The one girl, sure, whatever money was theirs.
Okay. How did you get home? Okay. Do you know how these other individuals that came, do you know the other individuals live?
No,
Did you ever know where this defendant lived?
not close.
About what time did the other two individuals leave? Okay. Do you know if they left by, do you know what transportation they left in? Did they,
Some Uber, some drove. What's important is that he has to stay.
okay. Did you ask him where he lived? He is basically, he's a stranger to you. So you said it was a small apartment?
Yes.
You guys were all sitting together? There was lots of conversation that evening, early morning?
Yeah.
Did you get to know him while you were there?
A little bit, but like this kind of listen to music this one out, you know, that was common for what I would do back then. But music, have people over most of the time. I know this would be the last time I ever wrestled in my home. That I know.
He asked to stay. You said, why don't you take an Uber home?
He said, too drunk to drive. He has to sleep on the couch.
You didn't say, can't you walk home?
I don't say those things before. Has to stay. When I'm sleeping on the couch, I obviously I think it was gonna happen. It was gonna happen. But in the house, I knew it was gonna happen.
And you said he was intoxicated? Did you watch him drink at your house?
Yes.
You know how many shots he had, or what were you drinking?
I can't remember exactly what he was drinking. It was either whiskey or tequila or vodka. Those are the kind of things I had in my house.
How much did you drink at the bar and how much did you drink in your house?
But I see where you're getting at with all this.
No, you just need to.
I had probably 4 or 5 drinks at the bar, probably 1 or 2 drinks at my house.
You say he woke up. Do you think that he, let me rephrase. after this evening, did you ever have any additional? Did you ever hang out with the other two people outside of this person?
So anytime I would run into him, because like over the course of the years, like I worked different marketing or event planning and roles in different parts, he was always addressed as a priority threat.
No, just strictly the other two people that were there. Did you ever run into them?
The girl, no, like, probably, but I don't know. This is something just can't recall.
You never told them what happened.
No,
You didn't go to the police the next day.
no.
You didn't call the police that evening. And this would have been about 4 or 5 in the morning.
This would have been later in the morning, like 6 or 7. Everyone left at 4 or 5. He stayed over. I fell asleep. I woke up to him walking in here. Steve Valley.
So you didn't call the police. Did you? You said it took them 5 to 10 minutes to listen to you to leave.
Yeah.
You woke up and he was standing up.
He was in my bed. Hey, you've been listening to this.
Does he, after you start screaming at him, does he stand up?
No,
Well, the question is, does he stand up at some point? I mean, he doesn't crawl out of there. Sometimes he stood up from the bed. Okay. So how many minutes were you screaming at him to get out of the bed?
nearly 5.
Took you 5 minutes to get him out of the bed? And when he stood up, how long between did it take him to leave?
25.
I could have a moment here.
Yes.
Did you have the TV on? Was there light in the room when it was dark? Okay, so it was pitch black.
It was dark. Yeah, it was still light because the sun was up.
Okay, how many windows do you have in your room? Can you tell me what type of tattoos you saw on his body?
I just remember it's thick and blonde black hair.
When you say his hair, where was his hair? What you're describing it as blonde.
Yeah.
Well, what part of his body?
So,
Does he have any tattoos throughout his body?
he didn't have the facial tattoos they did today.
Okay, but on his torso, did he have any tattoos?
Can't recall. Recently, absolutely not on time.
Thank you. Can you read her?
Just a few questions here. Thank you. Mr. Kwasny, you mentioned that this was just one of those situations where you were out, you were drinking, having fun, and then people came over to your house to hang out. So that's something that at the time would happen frequently.
Yeah.
And was it a frequent occurrence to have their friends join and just kind of come to your place to hang out? After what Mr. Lee did to you, did things change?
Absolutely.
Okay, can you tell us a little bit about that?
So one of the things to stop having people over as often is stuff kind of stuff would be kind of like, something like that happens. Rethink your life, have yourself in those situations.
So would it be fair to say that what Mr. Lee did to you had an effect on your life and mindset? And how has it felt having to show up to court a few times and testifying today?
Always for speaking to that.
Is it easy for you to talk about what has happened to you?
I think it's easier as I have to talk about it, but it's not easy.
Thank you. Nothing further.
You may step down. Thank you, sir. Call your next witness.
Your Honor, people don't have any other ones.
Any witnesses for the defense?
No, Your Honor.
So, Your Honor, a few things. First, I would motion for bind over on the count we have in the complaint currently. I would also need to add count 2 of indecent exposure. That's under MCL 750-335A 2A.
335A.
Let's see, 335A. It's actually it's a 1-year misdemeanor and or $1,000 fine. So I just ask that follow along with that felony.
Argument. Cedric?
Argument?
Yes, as to the bind over.
As in bind over, obviously, I know the court has the ability to weigh the credibility of this witness. This is an event that occurred 6 years prior to the date of reporting. His testimony was a little bit fuzzy about who he was with. And the occurrence of having knowledge of this event would have been more clear in his mind, having somebody come to his house with another girl that was, he testified that was a friend. He can't recall who that friend was. And he doesn't recall who his other buddy was, but he would call them buddy and friend when he doesn't even know their name. I think that's an indication that along with the intoxication that he had been drinking since 9, had been drinking all the way up until 4, I think his memory might be a little bit fuzzy about the situation. I just don't think that there is enough question of fact that this actually occurred. So I'd ask the court to not find over on either counts 1 or counts 2.
I don't need argument. Court, in listening to Mr. Kwasny, I guess I deeply disagree with the defendant's or defense rendition of his memory. Those things that certainly are important to him or were important from that evening, he has very vivid memory of and gives a very visceral response when he's asked about it. As to, while it's certainly not relevant, I don't believe it's certainly something defense may argue regarding the time. I also think Mr. Kwasny explained that in that it was not something that he wanted to discuss, and that after as time went on and he was talking to other individuals, that's what led him to come forth. That is not uncommon, certainly in cases of sexual assault. So while those are arguments that the defense makes, I don't find them very persuasive. I do find his testimony as to what occurred that evening, or that evening into morning, I guess, to be very credible. I believe that telling the court the absolute truth about what happened, and that he was screaming for Mr. Lee to get out of his bed, and that it took some time, and he's very specific as to certain comments that Mr. Lee made regarding that. So for those reasons, the court would find that the people have sustained a burden and would find a defendant over stand trial on the criminal sexual conduct degree with the added count of indecent exposure following. You're going to need a new information on this with the added count to that. So are you waiving presentation of that?
You would make presentation, Stan, you would ask for a brief.
All right, defendant having waived formal reading. Standing mute as to both counts, court will enter a not guilty plea. Pretrial in this matter will be set for
October 7th at 1:30 with Judge Hunt.
October 7th, 2025, 1:30 before Judge Cuffey. Thank you.
Last week he got over it, but he got over it and he said this is gonna get it right. He was done with the paper and everything, I was the pirate schemes. So. He was happy. Big artist.
We begin with the trial docket here on Jovan Nevo.
Ready, Jeff?
Nevo. And that's Ryan Matuska.
Yes,
Not here.
He's,
Unready? You ready?
yes, sir.
Ready or not ready? We don't know.
He told me he would be ready for it.
I wish you'd tell me. I was
I'll be here.
what do I know? Deontay Bird, Joe Vasquez.
Good morning, Alan.
Yes, Joe. On this, y'all ready?
Client is asking time to hire a lawyer. I would never raise. Yeah, just as one, it's actually been passed several times. I've stayed in the past. I think Sonny Mae thought there was a.
My God, he's 5 years old. He's now looking for a lawyer after. Are you kidding? After
He must have saved one.
60 months have gone by. Now he wants time for a lawyer.
And Your Honor, with that, this was Sonny's case, but the victim in this case is starting school back this week in Austin, just to.
Okay. What's that? So what does that mean? Feels,
I don't think we would oppose him to get another attorney quickly to reset it, so it's not right at the beginning of school with the victim going back.
Thank you.
That's right. The keys. I think the others.
I see the staff judge on the line had miss twice. That's all I have.
He's on phone. Please search.
Okay, let me go look. It may have been an oversight.
But
Good morning.
he didn't make it to this file. I'm ready.
Should be. Should be third.
All right, we're gonna pass on that one.
Thank you, Judge.
Ricky Johnson.
That's Mr. Matuska.
This is weird. I had Jonathan Garcia, which is not on the docket.
Sorry, that's an oversight on my part.
And I have Jonathan Garcia, which is not on the docket.
Well, that's what I'm saying. I probably pulled
Okay.
Yeah, I pulled the wrong,
Well, that's okay.
I mixed up the numbers.
Deontay Burton. All right, get back, Joe. Who got out of here as fast as he could. Uh, Ricky Johnson.
That's Mr. Matusz, this also.
Ricky Johnson,
Very good.
were you waiting for the introduction? The band of Ricky Johnson. And there's Ryan Matuszka, starring Ryan Matuszka. On Mr. Johnson's case, obviously, these two very serious cases. Where are we on this, Ryan? And what are we doing today?
Judge, I was, thinking we might go on the older case, Evo, but I could Evo the first one on the docket. If Evo works out, I can be ready.
All right, so, okay, so
We'll both have to scramble if Evo works out.
is there, out of all these, is there any pleas at all? There's none? I'm the only judge on the planet that never gets a plea on a plea docket, on a trial docket for some reason. Anybody want to say anything? Why? What, yeah, what, Tom?
When it's a job, I can't.
Sir?
I will.
Yeah. Oh, I'm inviting. There are no pleas on this over and over. And all we do is, and we got thousands in backlog, but it's not that way in other courts. Why? Is it me? Is it my cologne? Deodorant? Anybody? Tom, you? You got an idea?
I got what unlike to get from my country around.
That's nice. Almost there. Yeah, y'all gotta help me on this to figure it out. But otherwise, it just keeps going back. It just keep backlogging. So on Everfield, y'all are ready?
Ready, Judge.
Your Honor, the detective on that one who did download the videos, got all of it, all the photos, he's out of state for this entire week in Boston.
What do you want to do?
Judge, the court's heard this case once already. Darionte's here.
What happened? Help me.
It was the subject of an MTRP hearing. The murder was. The court did not make a finding. And it's now on the trial.
They did not make a finding.
Your Honor,
A number of
you actually revoked the defendant and sentenced him to 10 years TDC on the motion to revoke. That was my recollection.
The court did not rule on the murder.
Oh, okay.
That's why it's still on the trial.
Yeah. So
During
there's two cases pending though. So
That's correct, Your Honor.
tampering and a murder.
right, the tampering was indicted after the MTRP hearing.
Mhm. Well, That kid couldn't be tried. Tried anyway today.
No, Your Honor,
Because-
main investigator, Detective Robin, couldn't be here. He's
Place it at the top of the next trial docket.
just,
Okay, which is when? Tom can have an idea. Thanks for helping me out on that.
I'm more sensitive to Mr. Boyd's schedule than.
I would just ask Your Honor if it could be at least 2 weeks, because he's coming back after this week, but I don't know if that's going to be on Sunday or when it would be, and I'd like to be able to visit with him too.
August 25.
Yes, Your Honor, that work.
Okay, August 25. Thanks.
Thanks.
Okay, Cody Arnold. Y'all ready? Right.
That one you said, good answer. Some people. Thanks.
Okay, Kenneth Jackson. That's you.
You had that a couple of weeks ago and you said it, I'm gonna call out Landry. That was in the record case. It was based on a bond and you pushed him up for today, which I knew wasn't gonna go today. So I'll just call and then have you consider something on the budget. He's been in for,
What do you mean? You'll consider something or whatever I need to do on this?
we asked for a bond.
Oh, okay.
That was one of the reasons why you moved it up, Judge. We just need time to shuffle who's going to take care of that case. But the state was ready with Mr. Eckhart. We'll be ready again if even a week, 2 weeks, whatever.
But we're not ready today.
Well, we don't have a posture.
I understand. Okay.
There's a big difference there.
Okay, on Jackson. We said that for 4 weeks. Thank you. Dalton Kirk, please.
He's on page 5.
Dalton Kirk,
To your right.
that's passed. Orlando Durgan, please. Brian, sir,
He's present.
y'all ready?
That was him.
Okay, well. Let's do this. Kenesha Hawkins, please.
She's in custody, Judge. We're ready.
That's a case, Judge, that involves the death of a 5-month-old that has 3 different jurisdictions of doctors involved. So I need a special setting on that so I can get the
Can y'all-
doctors lined up.
I'll
let it
decide
pick a
on
date.
one for me.
Okay.
For you, okay.
We'll look at his
Please,
schedule.
If y'all can get that.
Yes, sir.
Okay. Yes. Send Andrew Hoosier.
That's fine. More ready to judge. There's an offer, but Mr. Hoosier, we sent to the court, told me.
He's not here. Andrew Hoosier.
Victim was present this morning.
There's,
and advised that they've been in communication with each other.
can that be? Or is that against the
I've
rule?
advised her that that's against all of his bond conditions.
Andrew Hoosier? Sir Andrew Hoosier?
I don't think Dennis hears you.
Andrew Hoosier?
We did send documentation to the court, Judge. No, it was a week ago. The date was on it.
Sounds like it's here.
Sounds like he's here.
Yeah.
I just have a second to talk to him, Judge.
Sir?
I have a second to talk to him. We may be able to. Yeah, that's it.
Mr. Hoosier? Mr. Burbank needs to talk to you about this case. Pay close attention to him. Thank you. Bruce Calhoun? Ms. Langston? It's here.
Yeah, I think he was working on some judge on that tablet, but I don't know.
I'll get back to him. Jerry and Elam. Ryan?
Mr. Elam got 50 years on an MTRP in October. November, he appealed it, so we're just waiting on the appeal. I think that's.
Is that what we're doing? We want to pass this?
You sure?
Okay.
Once that appeal comes
Review
through,
it.
we'll.
I'll put it on a review doc.
Review in 4 weeks. Okay. Let's pass. Adrian Ball, please, Mr. William? Adrian Ball. Anybody heard? Sarah, have you heard from you?
It's not, I talked about this case, we talked about offers.
A lot of talking, it sounds like.
But I don't know where he is today.
There's a lot of talking, no showing up. A lot of talks. Dagan Rutz, that's Langston Adams as well. You're Mr. Rutz? Is it Roots or Rutz? It's Rutz. Okay. I think he's in the back talking to another client. Thank you. Joseph Samuel. Les Langston. In a minute, I'm going to get Langston out here. Okay. John Guillory III, David Crow.
Yes, sir. I've been over with him last night.
I'm Joseph Samuel, one before, Mr. Adams, I think is signing him up for a plea.
On Samuel?
Yes.
What about John Guillory? That's.
John Guillory's mine, Judge.
Is he outside? John Guillory? I asked the bailiff to call into the hall for John Guillory III, please. Unlawful possession of a firearm, that's going to go to trial? It never goes to trial. Oh, it's an habitual. Oh, that could go to trial.
Yes, sir. Never been taken up my cases.
What is this bomb, please? I'm hearing some calling out there. No response to that name being called into the hall. No response to the name called here in the courtroom. Defendant has failed to appear. A warrant shall be issued for his arrest.
And the bond is currently $7,000.
The bond is, well, it's a trial docket day. Bond is $50,000. His bond is revoked. Bond is ordered in the amount of $50,000, plus he must have a GPS device as a condition of bond. So we know where he's here, where he is when he's not here, when he's supposed to be. Donald Kelly.
Yes, sir.
John.
I'm here, Your Honor.
That Mr. Kelly.
Yes, Mr. Kelly.
Hey, Mr. Kelly.
Yes, sir.
You can sit.
You're
Yeah,
okay.
this is, we're just talking to a lawyer here. Hey, Langston, we have a bunch of stuff. I'll get to you in a minute.
I've got a plea off the top that I just did. Right?
Okay.
That's Joseph Samuels.
Okay.
I'm flipping. I know I. Yeah.
He never stops. This is something I want to Energizer Bunny. Okay, on Donald Kelly. What? That trial?
The unusual type.
That never goes to trial. You either comply or you don't.
I tried on the floor.
Really?
Yeah.
Here? In this court?
This court, we sent over to drug court. Me and Dan did one time. But yeah.
Wow, those are wild cases to try. All right. All right.
I understand.
What's the punishment range on this one? Is this third degree?
Yeah, 2 to 10.
Yeah. Yeah.
I have heard a cap of 6.
James Franklin. Mr. Franklin, James Franklin Jr. He's in jail. And there's no answer on that one.
It's going to be a plea.
Langston, where are y'all's? Okay, let me, any others? No.
That's it.
Jonathan Naveau is going to be one. Mr. Matuska and Mr. Lee. The Deontay Bird case is going to have to be reset, correct, everybody? From the district attorney and Joe left. On Deontay Bird, that has to be reset, correct?
Yes, sir.
Okay, we reset. We'll have, can I put Ricky Johnson 2 in the event Naveau? But that's pretty certain, isn't it?
Yes, sir.
All right, well, I'll just put Ricky Johnson 2. Since it's the same lawyers. Cody Arnold 3. Dalton Kirk, that's going to be reset. Orlando Durgan has to be reset as well because of the prosecution issue. Kenesha Hawkins would be 4.
No, Judge, that's the one we have to special set.
No, that's a special setting. There it is. I got that written down. Bruce Calhoun is 4. Okay. It's Miss Dobbin, Langston. And Adrian Ball 5. Dagan Rutt 6. And 7 is West on Don Kelly, and 8 is Franklin. And that covers that bucket. Okay, let me get the plea on Hooser. And what is yours?
Joseph Samuel.
Samuel. Samuel.
I think Samuel is ready. I just need to pay him.
Okay.
I mean,
Joseph Samuel. Yours is who?
I'm the only one.
Is it Hooser?
If you got your please.
Yes.
I'm listening to you.
I have a couple blue
You
belts.
know what Hooser means?
Indiana, who?
Yeah, I know. And where'd the name come from? What's it all about? What's a Hoosier? I know it's from Indiana, but what do they mean?
Corn grower. Is it? No, that's Purdue, the iron makers, boiler makers.
I really think it's Hoosier. It's a question. Who's your
daddy?
That's what. Not daddy.
You're good.
Who's your judge?
It's not like who's your daddy.
Who's your no? Really? No. No. It really comes from. It's an old saying, historical, and it was taken from the. It's related to the defense bar, which is who's your client, and because you ask that, and then there's silence, and that's so they caught up with that. They started calling defense lawyers who's your client, because there was always no answer. That was just for the bar in Indiana. That was just for the state of Indiana, but it can be used for other states too. All right, who's ready?
I'm ready.
Come on up. Who is it?
Joseph Samuel.
Samuel.
You need to come in front of me first. So
Is the
Who's your client?
who's your club?
I got the big thing.
Oh. That's not my best. You don't have to be mad. Oh. Let's not.
Daniel, please will you write me in? You start one hundred.
I don't know. We didn't.
Up you guys. You should think of your written. I know it's hard. Is it flat? You can, I need it much darker than that. It's been this. Look, put it right there. Yeah. Okay, much better.
I have Joseph Samuel Bernard III.
Yes, sir.
Is he?
He's in.
Joseph Bernard Samuel with that. And you were here with Mr. Adams, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
That's a yes. Okay.
Yes, sir.
In summary, in 23 CR 1866, this indictment alleges, which is the state of Texas versus Joseph Bernard Samuel III. This alleges that on or about August 2nd, 2023 in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you're charged with here, sir?
Yes, sir.
We're only going on paragraph 1?
Yes, sir.
Okay. This means that if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, a sentence to 18 months in the state jail, given credit for all time served. And they're only proceeding on paragraph 1, not the enhancement counts. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge then, guilty or not guilty?
Guilty, Your Honor.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objections.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, cross-examination, confrontation of witnesses. You were totally satisfied with the representation provided by your lawyer here. All true. It states so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, yes, sir.
All right. Late night.
Late night.
I'm going to follow this agreement and find you, sir, are pleading guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now so find you guilty beyond a reasonable doubt of the state jail felony of burglary of a building as charged in this indictment. I am following this agreement. You were hereby sentenced to confinement in the state jail for 18 months, and you will be given credit for all time you have served.
Thank
Do you understand what has happened today, sir?
Yes, sir.
Okay, back to you. Sir.
Thank you. Yes.
Hooser?
I think he's on bond. He's, right.
Yeah. It was, I got the camera, is it? Should not.
Mr. Bruiser, over here, please.
Yeah.
Yeah. Well,
Where's the right hand? Where are we? God?
This is being reduced to the lesson of class A misdemeanor for failures occurred at $500 fine.
You can, I mean, I'm not gonna stand this. Place right here.
Andrew.
Flat, don't roll it. And
One page.
Yes, sir.
in front of you.
And we now call 23 CR 140, the state of Texas versus Andrew Chase Hooser. That's you, sir? Yes. Present with your attorney, Mr. Burbank, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does, and you may, Your Honor.
Now, let me ask you, I'm glad you're here. Hooser, the background, what, it's a family name. It's used as a surname here. But what's the derivation of it?
I can't remember. I did look it up.
Did you
It started off as like a Hoover or something like that, and it changed over time.
Oh, it's like somebody interpreted the sound differently and then started changing the letters in it. It goes way back though. It's interesting that I really haven't run into anybody with a Hoosier as a surname. You know, you know all about Indiana, but and the reasons their name, the base, from what I hear, was just a misunderstanding of a phrase that was used a long time ago. That was commonly used by people. But anyway, it makes you unique.
I mean, I'm just people with the same last name.
You have.
Yeah, I'm pretty sure related to down the line.
What are the odds of that? I mean, just randomly ran into them?
Yeah.
What are the odds of that? It's only 7 billion people on the planet. Wow. Okay, in 23 CR 140, you were here with Mr. Burbank, your attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in something?
Just one thing, Your Honor, it's associated with cleanliness, neighborliness, and pride in Indiana.
Isn't that, sounds like something they wrote? Well, those are all great things.
We waive formal reading.
All right. In summary, sir, this indictment alleges that on or about February 20th, 2023 in Jefferson County, Texas, this states that you committed a third-degree felony of assault on a family member. Do you understand what you're charged with here? And we've been kind of light on this, but this is a most serious charge. Do you understand? I understand. Because it's dealing with the complainant in this case is related. Is that your spouse? Oh, well, no, that's the most special relationship you're going to have on the planet, right? With the spouse. Okay. Everything working together.
She's actually present in the courtroom, Judge, and it's at her insistence that I'm doing this agreement today.
Okay.
They are working on the marital relationship.
Is that right?
Yes.
Do you want that? You got to earn it every day. You're talking to somebody who's been married a while, but yeah, you earn it every day because you work better as a team, as a unit, and and when it works, when you're doing the right thing, it makes you a better person as well. Striving to be the best you can be, not just to impress your spouse, but I mean to work together as a team, so that the blessings of liberty in this country can be shared together. Y'all have kids, children?
Yes.
Okay.
The worst thing about these facts is that the assault occurred in front of the children.
Well, y'all are fixing all of that.
Yes.
The most impressionable thing that a parent gives to a child is an example. Well, you have to make good examples because they're going to emulate. I did. Everybody, that's how they learn when they're young, is the parents are perfect. And then do whatever the parents want. You must, and parents make mistakes and the kids learn, people make mistakes. How you deal with the mistake is the real test of character. Everybody makes a mistake. We all do. Everybody in this room. Everyone. How you deal with it and fix it is really what kind of person you are. Are you dealing with this responsibly and committed?
Yeah.
Just be good for you and the family. All right. There's a plan here where. Okay. You would be pleading to a Class A misdemeanor. This is generally a third-degree felony, which carries with it up to 10 years in prison. Lesser included, what is the...
Up to 2 county.
Sir?
Up to 2 county, 4,000 bond.
No. What's the crime? What's the...
Class A family assault.
Okay, assault. Class A misdemeanor assault.
Yes, sir.
All right. So this carries with it a Class A misdemeanor, carries with it up to 1 year in the county jail and or a fine up to $4,000. Do you understand?
Yes.
Why does this have misdemeanor no more than 2 years?
It's supposed to be 1 year.
Up to 1 year in the county jail. Or these are impossible to write on. We're getting new pads, right? Are we getting new pads? Can't wait for that. I mean, this just,
We have to wait for the new
There's-
year.
you understand the punishment range applicable here on this, sir?
Yes.
An agreement has been reached further. You would be pleading guilty and placed on deferred or unadjudicated probation. You would not be found guilty. You would be fined $500. This can be to 2 years. And there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this lesser included Class A misdemeanor under this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes.
And because you are guilty?
Yes.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, if you could. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are given your rights to a jury trial and the rights to the appearance, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, I do wait.
I'm going to follow this agreement and find as to this lesser included Class A misdemeanor of assault, family violence. You are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea, to find you guilty beyond a reasonable doubt. But I'm going to postpone, defer any finding of guilt so long as you follow these terms and conditions of probation. They will be reviewed with you by the probation officer. You will be on probation for 2 years. There will be a fine in the amount of $500. You must complete batterers intervention prevention program as directed by the probation office and the court. And if you complete this, the case will be dismissed without a finding of guilt. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 1 year in the county jail. Do you understand what has happened today, sir? How long have you been married now? 13 years. That when I asked that, people, the first thing I got to think of it. I got to do my calculation. Sir,
Your reminders.
yeah. Well, and man, do you understand what has happened today? This is all y'all are. You're on board with this. Oh, nice. Well, committed to fixing this, huh?
Yes.
Then you may kiss your bride and good luck with this and best to your family and the kids. Okay. Be the good role model I think you're able of being. Okay, sir. Anything else?
My big speaker.
That is all. Please see the probation officer right behind you.
I don't know.
I love doing weddings, by the way. It's just really neat time. Who's on Michael Hersh?
I'm your.
Come on up now.
He should be brought out. Michael Hersh.
Michael Hersh, please. Thank you.
That's gonna be in the next, that's not on the trial docket, Judge.
Okay.
It's in the next docket.
Okay.
What?
I'm gonna get that.
First.
Jackson. Yeah. Which Jackson?
I see. There's two cases. Is that right?
Yes.
Right.
He needs to keep them. Square in front of me too.
Here it is. That's just market. Yeah.
Michael Hersh, please stand in front of this lady. She'll swear you in on these and then come before me. Thank you.
Please raise your right hand. Swear or affirm. True stuff to God. Ain't that the old white up front? Place it right there on the box, hold it. Ink it up on the thumb.
Two cases are now called on Michael Anthony Hersh. That's you. Present. Correct with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive formal readings of these two indictments in 24 CR 2326 and 25 CR 76? Can we proceed summary?
Yes.
In summary, 2326 alleges that on or about October 16th, 2024 in Jefferson County, Texas, you committed the state jail felony of burglary of a building. And in 25 CR 76, this alleges in some summary that on or about May 4th, 2024 in Jefferson County, Texas, you committed the state jail felony of illegal possession of a controlled substance, namely methamphetamine. Each of these are state jail felonies, which means you face no less than 180 days up to 2 years in the state jail and a fine up to $10,000 as to each case. Do you understand what you are charged with?
Yes, Your Honor.
And the punishment range for each case?
Yes, Your Honor.
Agreements have been reached where you would be pleading guilty, sentenced to 2 years in the state jail in each case, and that would be suspended. And you would be placed on probation, which can be up to 5 years in length. There is no 5 year, correct?
076 to $500 fine and no fine on the other one.
Okay, yeah, I'm looking at it. There is no fine on 2326, correct?
Yep.
There will be a fine in 76 of $500.
Yeah, that's correct.
Is that your understanding of the agreement, sir, in each case?
Yes, Your Honor.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, Your Honor.
How do you plead in each of these, guilty or not guilty?
Because I'm going to with this private office. I think it is listed.
Are you pleading guilty voluntarily and because you are guilty?
It's not very good.
Showing you what's marked as states exhibit 1 here. Mr. Come here, you need to sign on that.
We'll look at the new evidence.
I'm going to ask you, did you sign those documents? Did you understand them, discuss them with your attorney, or the contents true and correct?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence in each of the cases without objection admitted. Among other things, the state that you are mentally competent to enter your guilty pleas freely and voluntarily, mate. You know what you've been charged with, and the indictments have been read to you, brother. You are guilty of the crimes charged in any less included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. States, so help you guys. States Exhibit 1 made a part of the record in all cases. My sentence report is waived in these cases. I'm going to follow these agreements and find in each of these cases, you, sir, are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these state jail felonies. I am following these agreements. You are hereby sentenced to confinement in the state jail for 2 years on each case to run concurrently with each other. And that will be suspended. You are placed on regular probation for 5 years in each case to run concurrently. There will be a fine assessed in 25 CR 76. There will be other terms and conditions of probation, which are normal and customary. Please make sure you follow those. If you fail, your probation can be revoked and you can be sentenced up to 2 years on each case.
Sure.
All right. You understand what has happened today, sir?
Yes, Your Honor.
And please see the probation officer. I'm going to sign these papers here. We're going to also send you over to drug offender education, a drug offender education program that will help you on dealing with a drug case, and it's always a good thing. That's yours. There we go. We see the probation officer. Thank you. Good luck. Do we have anything else from the trial docket?
There was an add-on just to the docket itself before we get into the jail run.
What?
Otis Pollard, which is the Malby.
Thanks. Add on. I don't have an add on.
Sir. It's up there.
What's that for? What's this hearing all about?
Judge, the files up there is that motion to withdraw we showed you on Friday.
Friday?
Yeah.
That's the day before Saturday, right?
You should have it, the files with the motion rubber banded around it.
Here's Deontay Bird. That's reset.
If you want to hand me the trial files, Judge, I can get that out.
And you all these files. Yes.
Yeah.
Here. Here's number one. On filers, what's this hearing, or is this the motion to withdraw?
Yeah, that's correct, Judge.
Are you ready to do this now?
Sure,
Okay.
whenever you are, Judge.
Okay. So we call the matter of Otis Pollard. Is it Pollard or Pollard? Pollard. And in 25 CO 138 and 139, that is you, Otis Pollard?
Yes, sir.
You're charged with unlawful possession of a firearm by a felon in 138 and 139. Otherwise, in 138, that's a third degree felony. And you have prior convictions. So this is a habitual felon status on this case. So if convicted of this, you're looking at no less than 25 years up to life imprisonment on 138. On 139, it is a state jail felony of theft, and you paragraphs 1 and 2 constitute a state jail felony because you have 2 or more prior convictions of theft, which means when you steal a pack of gum, it's always a felony from now on. And then I've got 2001 and 2011, 2 prior convictions in sequence that will elevate the punishment to a second degree felony. So you're looking at up to 20 years imprisonment on 139. Do you understand all that? Okay, and not good news. I know there's a motion to withdraw that's been filed by your defense counsel, Ms. Minaldi. And did you want to add anything to this?
No, Judge, I do not. Just that we just have some irreconcilable differences and there seems to be a major communication issue. So I would just appreciate that being kept within the court, and then my motion to withdraw being granted due to those.
Okay, are you familiar with what this says? Anybody want to add anything? Because this is disturbing to me because it's hard to find good lawyers to come into this court, and the ones we have are good lawyers. But they are here, and I was the defense attorney for a long time. They're here to help people, their clients. They help. She does. And what I'm reading here is vulgarity, abusive language, threatening, and all of those. She doesn't deserve that. And nobody should treat someone like anyone with abusive language and threatening language, especially someone who took a sworn oath to help her clients.
And my staff as well, Judge.
And staff. Well,
the lady
and it may very well, and these very well may be crimes too committed, in disorderly conduct or threats, which you don't need those with what you're facing. But I am not going to subject. She's one of the public defenders who I pick and choose because I've tried. Only the good ones are going to be people I choose in this courtroom, and I'm not going to allow her to have to be subject to that hostile environment. So yes, I'm going to grant this motion. She's released from representing you, and your excuse.
Thank you, Judge.
Thanks. So what are you going to do about getting a lawyer now? What are you going to do about getting a lawyer now? Sir? How much time do you need? I'm gonna give you 4 weeks, okay, to talk to some people. But there's nobody's gonna represent you when you treat them like that. Let me just say this. I know her to be, yeah, I'm sure you have a different side of it, but he wasn't there. But the point is that this is disturbing. Yes, and I don't want her in this environment. But yeah, what this says is very disturbing and can be criminal if found true. You have 4 weeks to go get a lawyer on these two cases. Make sure they know. I'm going to give you a resetting. Make sure they see that resetting so they know what the time element is. Do you understand?
Yes, sir.
All right. Get a resetting. Thank you.
Just put it right here. I'm gonna reset it here. Withdrawal.
Okay, this motion to withdraw has been signed as to each case. And Ms. Minaldi is free from representation on this matter. And Mr. Pollard is going to hire an attorney, and he's got 4 weeks. If you don't, you got to come back and we'll figure out how much more time, but let me know who you talk to and what the situation is, okay?
Yes, sir.
Dustin Keffer, where is Dustin Keffer?
That's mine, Your Honor. He's in custody.
Because in custody.
Do I get my flush?
We'll have the clear VA office. That's what I'm trying to do.
Here's that trial docket.
Yes, sir. Copy this.
Who's that shoemaker? You got, that's going to get disposed of, huh?
We're going to dispose of 7 out of the 10 cases. Not too bad.
I should live so long to get through 7.
Yeah.
You're Dustin Keffer?
Yes, sir.
Oh. Yeah.
Just he needs to come swear me.
And I need those. It's
Yes,
fine.
sir. Raise your right hand, you swear for her, tell the truth, the whole truth, and the truth, you got, and speak of your right thumb, yeah. Hold on.
We did Hersh already, right?
Yes.
And then you just place it flat right there.
I know.
Have it in. Place it right there, don't roll it, just place it flat. Okay, all right, just name for the judge. Pepper.
Okay. 24 CR 1619 is called your Dustin Court. Yes, sir. Present with Mr. Dustin, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 14th, 2024 in Jefferson County, Texas, you committed a third-degree felony of the fraudulent use or possession of identifying information of others. You understand what you're charged with here?
Yes, sir.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached where you would be sentenced, pleading guilty, found guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500, and ordered to pay any restitution that there may be. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents true and correct? State's Exhibit 1 is tendered into evidence.
No, sir.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea, and it's freely and voluntarily made. You know what you've been charged with. The indictment's read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance time cross-examination, confrontation of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. States Exhibit 1 is part of the record for all purposes. Pre-sentence reports way here. I am going to follow this agreement and find, if nothing further, sir, you were pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony. I'm following this agreement. You will hear sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for 10 years. That prison term will be suspended. You were placed on regular probation for 10 years. You must pay a fine of $500. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow this. If you fail, the probation could be revoked and you could be sentenced up to 10 years in prison. Please see the probation officer. Thank you. Right.
It is great, but.
Don, yes. What are we doing on Jared Dobbs?
They forgot to bring him here from the jail. We're going to reset 1 week. It's going to be completed, but we just didn't get on there.
Okay, Jared Dobbs.
So next Monday.
CR 6-8, reset 1 week for disposition. Amber Freeman.
We need her brought on. This is basically a review of.
Okay, I need her file. Amber Freeman, please. Thank you.
Freeman?
What'd you say, Don?
It's basically a review on motion revoke probation. She's pled true in 2022. And
what was the status?
Still in the past.
The status of her probation, is that what it is? I guess.
Yes, sir.
Where you certainly do not look like Douglas Gregory.
Yeah.
Was he the officer? Is he the officer in law?
Yes.
What happened to him?
So.
Transfer? Okay. Write me a note.
Let me show you.
The officer there wrote the admin here.
Really? Well, yes, that was funny. Hi. You are Amber Freeman and Ms. Cole is present here as the probation officer representing you here. I'm looking. Back in 22, you pleaded true to a motion to revoke probation, and I held all of that in kind of suspense. We continued the probation here. You were charged, of course, earlier in 2022 in this cause number 39635 with the second-degree felony of robbery. And then we sentenced, you pleaded guilty, you were convicted, sentenced to 10 years in prison. That was suspended. You were placed on regular probation for 10 years and fined $500.
Yes, I went to.
Hold on. I'm just doing a history on it for the record here. And so we placed you on probation 5/31/22. The next month, a motion to revoke probation comes out. 1 month. I've never had that before.
Yes, I was down on the method that in the.
I know. Let me just. And it alleges, among other things, that you committed disorderly conduct on June 8th and public intoxication on that and failed to report.
Yes.
So we had a hearing on that and says placed on the previous file MTLP. NPRP was filed in 6/7, so we added that. And when a first amended motion to revoke was filed on July 22nd of 2022, and we pretty quickly on August 1st, you pleaded true to those allegations, but also added in that though were trespassing allegations and appearing intoxicated. And so what we did, it kind of held that one in abeyance. And we continued you on probation in 2020. Then an administrative hearing comes up. Miss Nunez was your probation officer at that time. In April 16th of 2024, we kind of jumped up a year and a half or so. And you did attend substance abuse, felony punishment facility, and was successfully discharged, then transferred to a 90-day residential aftercare at the Nelson Center. And then we had some issues on that. And
Successfully discharged from the Nelson Center. I never had any issues.
If you're going to interrupt me,
Oh, okay, yes, sir.
you're going to get a chance to be heard. I'm just reading stuff under record. It's not a debate.
I apologize, sir.
Okay. Yeah, only one of us can speak at a time because she has to.
Yes, sir. I apologize.
I'll let you talk here in a minute. You want to talk? I know you do. Let me say my little spiel here. And then it was recommended that you enter and complete special needs substance abuse felony punishment. And that was approved by me in April of 24, a little over a year ago. And we modified the special conditions of your relapse safe P program at that time as well. What's that? And a new administrative hearing now pops up that I signed on June 27th, and Mr. Mouton had presented this. And this, it states that you have not provided a current address to the probation office. You're having trouble knowing where you live, and we have to know. You're not working faithfully at employment, attending an educational program, or performing community service restitution as required. You are not conducting yourself in a professional and courteous manner with the probation office during a team meeting on June 5th. That would be, 2 months ago? You repeatedly stated, "I am a prophet of the Lord. I curse you and your entire family." Did you say that? Do you remember saying that?
No, and
Or do you think
that was
they,
at my aftercare. She was supposed to just provide me for my next appointment.
are you gonna, yeah, let me speak.
Okay.
Do you think they're making that up? Do you think they just made that up out of clear net?
Yeah, but I am a prophet of the Lord. But I didn't do anything. I passed all my urine analysis. I showed up for a call for all of my colors for the day.
Wait. You missed this part, and I curse you and your entire family. That doesn't
Yes.
sound angelic.
For the dissent.
Hmm?
For their dissent, and amen. But she was provocating herself against me. She's not my probation officer. And I showed up to every aftercare.
Okay, hold on. You're gonna get to speak in a minute?
Okay, yes, sir.
You're speaking over.
I'm a little bit shaken.
Yeah,
because I don't understand all the precepts.
I'm using English.
Okay.
And don't speak over the court. I'm using English.
This is my first time.
Yeah, don't speak over the court like you keep doing. That's rude. We learned that in first grade. Okay, all right. So here are the findings. That it was recommended after this hearing that was being held with the probation office, and the court agreed to amend the motion to revoke probation with new violations, which are violating condition 5. You did not permit the probation office to visit you at home or elsewhere without restriction, and you have not provided a current address to the probation office. You violated condition 6. You failed to work faithfully at suitable employment, attend educational programs, and/or perform community service restitution as required. Condition 14, you did not dress appropriately and conduct yourself in a professional and courteous manner when interacting with the court officers and the staff, and they work for the court, by the way. Community. You know what? One more time, and we're going to put you in the timeout like we do with children, because you're interrupting this. I want to control everything. Don't. I mean, please follow the rules. That's your problem. You don't follow the rules. Violating condition 18, you have not completed any community service hours since being placed on probation back in 3 years ago. Condition 30, pay restitution. You owe a balance of $15 for restitution. Boy, that ought to be fixable, you know.
I was never told about this.
Pay the amount shown on this order. You owe a balance of $11,260. Oh, these are the court assessed fees, fines, community probation fees, and you owe an entire balance of over $11,000 for the whole term of probation, but you were in arrears $3,750. Violating modification of special conditions for the relapse safety program. You were unsuccessfully discharged from the substance abuse felony punishment facility program on June 5th. This is where we're picking up recent. Had the supportive outpatient through Spindletop because you were continuously late to group and you weren't showing up apparently. Okay, findings. June 4th, the order was entered for you to enter and successfully complete the safe relapse track and all aftercare requirements. You completed safe P unit placement on 12/3/24 and residential aftercare. It's very good.
Yes, sir. Thank you.
And after the discharge from residential aftercare, you were permitted to move to Taylor County. Is it Taylor or Taylor?
My plans for the may I ask your permission to speak first?
Yeah, hold on. Let me, do you need to, it says after the discharge, you were permitted to move to Taylor County with your sister. This was short-lived because of the behaviors exhibited by the defendant, such as making threats to the family and refusing to continue treatment for sobriety, and you were then returned to Jefferson County, placed in the safe P supportive outpatient through Spindletop on May 1st to continue substance abuse treatment. Right? Is all that right?
No.
Okay, you're going to correct me here. Hold on. It said during the group treatment, you were disrupted by talking to yourself loudly and claiming that you hear voices. It says you are not receptive to mental health treatment unless ordered by the court, but is adamant that no one can force you to take medication. A treatment team meeting was held on June 5th, and Community Supervision Officer Shakita Cole attempted to express concerns regarding your lack of mental health treatment. And you said, I am a prophet of the Lord, and I place a curse on you and your entire family. Because of this behavior and refusal to attend to your mental health needs, you were unsuccessfully discharged from Safe P outpatient aftercare on June 5th.
Unfortunately.
That you have no stable place to live in your current state. In your current state, probation office deems that you are a danger to yourself and maybe to others. There's nothing funny about this. No, nothing. You're laughing out loud. You're the only one in the room that thinks, and you're the only one in the room interrupting me.
Yes.
You laugh. You're interrupting constantly. Constantly. You're interrupting what I'm saying. Quit interrupting. Who does that? All right. Due to your instability and unsuccessful discharge from Safe P supportive outpatient, it is recommended that your motion to revoke probation be amended to include new violations and then issue a warrant and hold until the capias is issued and have a hearing on all of this. This was dated June 13th of 2025. I generally follow recommendations like this, but do you want to say anything? And then I'm going to give the floor to Ms. Frank.
You know, Judge, I think everything speaks for itself. And I think she can explain to you, as she has to me, that she has originally had issues with drugs. She has some mental health issues, but she does not rise to the occasion of being of incompetency. She did successfully complete safety and the aftercare program.
Yeah,
And I think it's
capability.
and I think it's just some problems that have resulted since then. He hadn't done anything else wrong. Hadn't violated the law in any manner. And she pretty much.
No, that's not. I mean, they're alleging conditions wrong. I'm not talking about committing crimes here, but the probation has a methodology that is proven successful. We have a 93% success rate. The national average is 75. And we want everybody. And I mean, that's high. That's an A. And so we want success. We're disappointed when we don't want to lose any people for revocation.
And Judge, the probation officer just notified me that she did not successfully complete either one, the inpatient or the outpatient.
I did.
Well,
I received a certificate of rainbow color for the Melton Center. And they came to see me at the Salvation Army. My probation officers know that I stay because he got me approved to stay at that of the Salvation Army. Okay. And he comes by there and sees me.
When can y'all fix this third amendment?
Your Honor, I can have it done shortly. I'm going through. I had a few
order that a third amendment motion to revoke probation be filed so we can get this heard quickly. It won't take long. I want a hearing on this as soon as possible. Everybody gets to be heard, and then I'll make my determinations. But we've got to have a formal amendment to this so that all the allegations are brought on the table so everybody can be heard.
That way.
Okay.
And just to be clear, I don't believe this second amended was filed yet. This was from June. Would you like me to file it all with the second real quick?
You can put it all in the second. If you want to call it the second amended, that would include what would have gone into the third amended had the second amended been filed. Yeah, we got to put it on the table and dot all the I's, cross the T's. and see where we go.
May I suggest?
Yeah.
Go ahead and set it on a hearing date since you already doing all the motion, let's do a hearing.
We'll do, it's gonna take a little bit, but, can y'all be ready in 2 or 3 weeks? Sure.
Yes, sir.
Sure.
Okay. Then, but it's still we gotta wait for the, and then we'll set it as soon as possible. So get ready, everybody. Okay, thank you.
Okay.
Yes, ma'am.
Thank you.
Okay, so Don, look, Carlos Landry.
That's so trial.
Carlos Landry, please. What about Orland Pennell?
That is our, he has hired Scott Rennick, and they've already made the adjustments on that.
Okay, I need Carlos Landry, please. Thank you. Who's I don't have a prosecutor on the sheet here. There's no name. Carlos Landry. It's a missing house. There's no prosecutor. It's a gap. It is. Well, space. There's nothing. Is it Sarah?
It's Sarah. Yes.
She said so.
Mr. Landry? Okay, so we call 24 CR 2098, the state of Texas versus Carlos Landry. You're Mr. Landry, correct? Speak out so we can, there we go. She has to take down everything. You have been indicted, as you know, in this cause number 24 CR 2098. And in paragraph 1, it states you committed third-degree felony of evading arrest or detention with a motor vehicle on or about September 9th, 2024 in Jefferson County, Texas. And if it were just that, I can understand we could probably work something out. But we got some other problems here. Paragraph 2 and 3 allege that on March 20th, 2015, in the court next door, the 252nd, you were convicted of burglary of a habitation on that day, March 20th, 2015, and also evading arrest or detention. And those, the burglary is a second-degree felony, the evading arrest or detention is a third-degree felony. So if you were convicted of evading arrest as alleged in paragraph 1, the third-degree felony, and if one or more of these 2 prior convictions was proven true, then your punishment range bumps up to a second-degree felony. So you're looking at up to 20 years in prison with all of this. Do you understand how serious this is? Okay. Mr. Dusler is here representing you. And of course, you're not eligible for regular probation if you have a prior felony conviction, as it's alleged in paragraphs 2 and 3. And okay, go ahead. Mr. Dusler on his behalf.
Yes, sir. The state has offered a plea bargain of 5 years in prison. He rejects that offer, wants it to be settled in trial docket. He would also like the case to be disposed of as soon as possible. So he's asking that I be relieved and a new lawyer take my place.
All that true?
Sir, can I say something?
Yes, sir.
When the thing went on, I had earbuds in.
Sir?
I had earbuds in. I had music playing. And normally when I have a minute, I had loud, right? So when I'm riding, I didn't really know the loud man was behind me. So I'm leaving out the Enterprise. I didn't even know the loud man was behind me. Okay. So when I slid, I looked up, he right there.
No.
You know what I'm saying? So,
well, here's what the probable cause affidavit says here that
look, he could have
please turn whatever that is off. Thank you. That's it. Approaching the vehicle with my lights out, the driver immediately attempted to turn down a side street, trying to evade. Lost control of the motorcycle, laid it on the ground. And let's see. Right. The check with dispatch showed that you had 11 warrants for your arrest at the time. They were going to find you sooner or later. You got the attention when you have 11 warrants. You were transported and booked in for evading. And it's all apparently on the video. But here's the deal is the fact that you had earbuds, that's not going to make a difference. I mean, you have to be able to operate your motor vehicle responsibly. And if you can't hear, you have to be able to see and hear when you're operating a motor vehicle or any type of motorcycles responsibly, so that you can hear like a horn being, if somebody is trying to blow the horn, or if the police are behind you. And so that's not an excuse. You shouldn't be doing that, because it's, if you were driving a car, a 4,000-pound missile, you can understand that's even more dangerous. But a motorcycle, when it's on the road, you have the same rules. You have the same rules you have to follow, and you have to be able to see and hear to avoid trouble, to protect yourself, and prevent injuries from others who you may run into because you're not listening. And you got to take the earbuds out. I'm sorry. You listen to them at home or when you're walking or jogging or whatever, but not driving a vehicle or a motorcycle. That's against the rules. You can't be doing that. It's unsafe and it's illegal. So
I wasn't even driving crazy. I was driving.
I know, but this says what it says, sir. So anyway, what are we going to do now?
I said on trial, I get me replaced.
All right. So this is what happened on the burglary and the evading arrest.
Received 4 years TDC on both of those after failing probation.
So you are ineligible for probation in front of a jury. Do you understand that? Since you have a prior conviction or two, a jury cannot give you probation if you go to trial. And so that would not be an option they have. That's why it's always kind of good to try to see what you can do. But if that's what you want, a trial.
I can take 3 years then?
Sir?
3 years.
That's, y'all got to talk that out, not me. If you want to talk to him, Mr. Dusler is a very good lawyer, and he'll talk to her, this nice lady. These are fair people. If they can work something out, they'll let me know. I'll give him some time here because it sounds like he's interested in it, but let him have a fair opportunity to be heard. Y'all let me know. Okay. Just have a seat there, sir. Thank you. Panel.
That's the one that stopped running to the Vanguard.
And do we? Okay. Okay, that's going to be reset. Then I don't need to defend it out. Austin Shoemaker. Oh boy.
Yes.
How many of these?
We're going to dispose of 7 of those motion to revokes. All of them are state jail felonies.
There's 2 new cases.
We've got 2 new cases and another motion to revoke that is a degree felony. We're not disposing of today.
What? Let me just hold that for just a second and go to if I have a life after that or not. Okay. Steve Thomas.
That's going to go on the trial lucky.
Okay.
That's all I have. Those.
David on Kyle Mulholland. What are we going to do? Is that
in this case, we have a trial docket. And there was a disagreement about a minimum charge.
Sarah's on that.
She was out of town and she decided, I believe, Your Honor, that she does not wish to go below the minimum So I believe it'll be set on. Set where it was before.
Okay.
But he had signed up for 20 years and they decided that he not wish to go below the minimum 25. I believe it's correct.
That's correct, Your Honor. I would like to see the overview.
Who is this? Who are you, sir?
Thomas.
That's Mr. Doosler's case. Mr. Doosler said he wanted a trial, and so.
Yeah, we need Don out here. Okay, now let me get back.
So I don't think we're gonna do anything today, Judge.
And on Jro McQueen, what are we going to do on that?
Sentencing hearing.
That's a sentence. All right. I need a defense.
Oh, yes, Thomas is mine.
Yes. Don, y'all need to be out here, you and your client. Okay.
They took him back to this, no, serious. You want Thomas or Thomas? Yes, thank you. Okay, Thomas, I'm sorry.
He's an accused.
Unless you're dealing with Dave.
I need that file on, is this it? Okay, it's Steve Thomas in 25 CR473. And you were Mr. Thomas and we're here with Mr. Doosler. You are charged here with this second degree felony of failing to comply with sex offender registration requirements. That is, that carries with it up to 20 years in prison, as you know. But the indictment alleges 3 prior convictions, a 2019 conviction, of failing to report a change of address for a sex offender. And that was out of Montgomery County, Texas. That was on March 4th, 2019. Let me ask you this. Is paragraph 1 and 2 part of paragraph 1? Does it roll into the substantive offense? Because it doesn't have.
No, Your Honor. That's another.
It doesn't say that it can be. Yes. And anyway, paragraph 3 goes on to allege that you were convicted of robbery in 2003 out of Montgomery County, Texas. And paragraph 4 goes on to state that after that robbery conviction was final, as alleged in paragraph 3, that you committed the offense of illegal possession of a controlled substance and were convicted of that in 2007 out of Montgomery County District Court. So the way this is alleged, correct me if I'm wrong, it's a habitual felon status. So if convicted of all of this, sir, you were looking at no less than 25 years in prison up to life in prison. Do you understand where you stand on all of this? And it's the most serious type of sentencing next to capital, like a capital crime for the severity, because there's a minimum of 25 years. So what are we going to do on this one?
This is a state offer and has to be sexual wrong. I mean, related, sir.
Which was what?
15 years, Your Honor, TCC.
Okay. Is that right? Is that right?
Yes, sir.
Mr. Did you need any additional time to think about this, or do you feel like you thought you understand what the minimum, if convicted, would be 10 years more than that?
Yeah.
Okay. do you need any additional time to think about this?
Yes,
Because,
sir.
but mathematically, it doesn't make any sense, but it's your life.
Yeah.
Everybody gets to make their own choices.
Yes, sir.
Is that what you want to do? Reject that, not take the deal, right?
Yes, sir. I need time to think about it. Get hold to my family.
Have you had a chance to talk to him yet?
Yeah, we talked a little bit.
Would 2 weeks do okay for you?
Yes, sir.
Okay, well, yeah. I'm gonna give you 2 weeks to think about it and we'll come back and pick this up, okay, sir? Okay, anything else you need to ask, Mr. Thomas, from the court or you?
Yeah, no, I'm on site medication.
Okay.
I need to talk to a site.
Oh, okay. Are the medicine prescriptions being filled properly?
Yes, sir.
Okay, that's important. Are you following the prescription requirements?
Yes, sir.
Okay, that's good. All right, we'll see you in 2 weeks. Thanks, Mr. Thomas. Tom,
Ready.
let me get you real quick here. McQueen. Jro McQueen, please. Need that file. Thank you. McQueen, Jro McQueen, please. Thank you.
Mr. Laird, please. I'm sorry. I would have said the same thing.
McQueen.
Yes, please.
All right, this have your seat in the box.
Thank you, Judge.
Thanks. We'll get to it. Let me. Is David? We lost David.
Judge, his was reset.
On Kyle Holland.
Yes, correct.
Okay, Don, let me get back to you on Shoemaker.
Yeah, hold just a minute. I'm signing up for Landry.
Okay. That's La Carlos, right?
Yes.
Okay.
Yeah.
Ma'am. All three people you're on are Leon Davis is first.
Who is it?
Leon Davis. It is one that was Mr. Edwards. I'm talking with Mr. Laird about.
What are we going to do today on that one? That's 25 CR 225. What do you want to do on Leon Davis?
I have 3 weeks on him to get up.
Reset 3 weeks at request of defense. Rex Allen Powell. That's an NTRP.
Same situation with that one. I have 2 to 3 weeks to figure out a resolution.
3 weeks. Rhonda Roberts.
Judge Ms. Staub has informed me that she has 2 more pending cases that are going to be set before a grand jury soon. So we're waiting on those 2 additional defense to come down.
Wow. Okay, so she's got 5 already.
And she's got 2 that are waiting on indictment.
Okay, so there'll be 7 total at the end of all this. Okay, Rhonda Roberts is reset. Okay. Anything?
That's all I have.
Yes, ma'am.
Thank you.
Barry Jackson. I called it, but nobody said anything. I called Terry Jackson, but John was not. John refused to acknowledge, so it's been passed.
I'm sorry,
he was talking to you. Remember, you and I had that plan. If you talk to him, he will be distracted, and I'll be able to bypass him completely. And so it worked out perfect.
It worked out good.
Plans.
What you wanted to do, Judge.
On Terry Jackson.
Your Honor, if we can get one more time.
I've got 2 cases.
Yes.
Yeah.
Me and Mike have talked about this. We need a little more time. And also, I think I may be filing for a mental evaluation on this one. So I'm not positively sure. Your Honor, I think I can figure it out.
Is, well, how much time do you ask?
Enough time to file a motion and get them evaluated. So say 30 days.
All right.
Or sorry, 4 weeks.
Okay, all right. Terry Jackson, reset, 4 weeks, 2 cases. Charles Kyles.
Chaz Kyles. Yeah, this is.
Is it Chaz? I'll be darned. It's CHAS, but that's, which is short for Charles, but there's no period after that.
No, it is Chaz Kyles.
Okay, on Mr. Kyles.
We've had this one time. We've been negotiating, but this is one of the
Other cases.
yes,
All
yes,
right, you need some.
yes, it is more time. Yes, that's
Is
exactly.
2 weeks going to be good?
Oh, yeah, absolutely.
All right, reset files, 2 weeks, please. Kizzy, now there's a name I've never seen as a first name. Kizzy.
Getting a couple of good names.
Kizzy Landry.
This is also one of these other cases that I need to
You need,
reevaluate.
is 2 weeks going to be good?
Yeah, I've been out on vacation until Friday, so I have not even been in town when all this.
All right, Amanda Nolan.
She's in the back and we can bring her out. If you want to go with the rest of them, that's an MTRP. And she's going to plead true to some and then let you decide what to do.
On Amanda?
Yeah.
What about Diane Rubin? That's 4 cases.
This is one that me and Dan have been working on. This is the lady who's had a bunch of issues, coughing, not vomiting. She's not even here. They didn't bring her over. It's just a status update. We get 2 weeks on that one.
2 weeks.
Yeah.
Diane Rubin, please. Robert Weaver.
Weaver and Williams next two are both the issue with the prosecutor. So if we can, I need to
What time? What time?
2 weeks on both of them. Any time to talk to them about it and get them taken care of.
Robert Weaver.
Same thing.
Felder
Weaver
Williams.
Yeah.
2 additional weeks. Reset for announcement.
Wrap on that, definitely. And then when we go back to Amanda Nolan.
Amanda, get her out, right? We want her out. Yes.
Yes, we need her out here to.
Amanda Nolan, please. I need Amanda Nolan's file. Hello. How much time does this lady have? Amanda Nolan is called and cause number 19-32306. That's you? Amanda Michelle Nolan. And you were here with Mr. West, your attorney, and the state's attorney. There is a motion to revoke probation file June 27th of 2025. Are you familiar with it and have you discussed this with Mr. West?
Yes.
All right, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hands. In summary, ma'am, this motion states that on November 18th last year, 2024, that in this court, you were sentenced to 2 years in the state jail, and that was suspended. You were placed on regular probation for 5 years for theft, a state jail felony, and that was theft, and you had prior theft convictions out of county court at law. So with 2 or more prior convictions of county court of law or district court thefts, anytime you still found your gum, it's a felony.
Yes, sir.
From here on. Okay. And there are 6 violations here. It says states are number 1, you failed to report to the probation office on or about April 10th, 21st, May 6th, and May 20th of this year in violation of your probation order. Is that true or untrue?
It's not true.
Ma'am?
True.
Two, you failed to work faithfully at suitable employment and provide verification of that in violation of your probation order. Is that true?
No, sir.
Okay. 3, you failed to immediately report to your probation officer your current address or phone number as required. Is that true?
No, sir. It's been the same.
Hold on. 4, you failed to provide all records and documents required by the supervising officer within 30 days of their instructions. Do you understand what that means?
Yes, sir.
Is that true or untrue?
True.
6, you failed to provide verification of entering and successfully completing the moral reclamation therapy program as recommended and directed by the probation officer in violation of the special amendment to your probation filed on February 24th of this year. Is that true or untrue?
True.
Are you pleading true then to allegations 1, 4, and 6 of this motion to revoke probation voluntarily and because those are true as they are alleged? Do you understand that a voluntary and knowingly made plea of true to 1 or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can be revoked and you can be sentenced to no less than 180 days up to 2 years.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
What says stay?
Your Honor, originally she was placed on deferred. She's given a chance then. She wasn't able to comply with that, was revoked, and then placed on a straight probation, 2-year probation for 5 years. And again, we're here again. She's not reporting, not complying with it. At this point, Your Honor, obviously, I think she needs to feel the punishment on this a little bit. She hasn't taken it seriously. And we're asking for 15 months, Your Honor. Thank you.
May I ask, you're asking for 15?
Yes, Your Honor.
Can I ask, is there restitution here?
No.
There was no restitution. No. Just let me. Okay, she got stopped. This was for a grand total of about $40 worth of stuff, right? But it's a pack of gum gets you a felony.
Yes, sir.
Oh, what's Mr. West?
Your Honor, I would like to have her testify, kind of explain to us what's going on here.
Go ahead. She's under.
Oh, okay. We put her on.
Go ahead.
Ms. Nolan, let's talk about some of these allegations. The first one is that she kind of absconded and stopped going in about April. Is that correct? What was going on in your life and why did you stop going? I think the judge needs to understand why this happened. This is not.
I have kidney cancer, which prior in November, they provided like documents to Mr. West and yourself. I know you do it, a lot of people might not remember, but I've had a nephrectomy on my right kidney. Half of it taken out in November. I had kidney failure, and that's how I stopped going in the first place. And in April again, I got sick, got pneumonia, and kidney failure at the same time in my kidney that I have. And then since I've been in jail, I've been missing 2 of my cancer appointments with my urologist. Like, that's the only reason I stopped going.
And so that's actually takes care of a couple of these different allegations. Also, regarding employment, you stopped working because your cancer was having some issues. And then on doing the moral recognition program, that was also stalled because of your medical issue, correct?
Yes, sir. I'm back on the payroll for unfair folk already though.
Okay, so you're back working right now, correct?
Yes, sir. I'm just being frustrated. I'm on the.
Or you will be if you get out and back on.
Yes.
Regarding the updating information, is anything new or changed?
No, sir.
Not that you know of. Okay, so you didn't know there's anything to update on that. Okay, and these documents, do you know what documents that you did not provide?
Me and Ms. Lopez, she was saying that she didn't receive my emails. If that's what it is. What I don't know the documents then.
That's what I'm getting at. You don't understand exactly.
No.
You pleaded true to that, and it's a generic, kind of a general allegation.
That's what I was saying true about the email.
What did that involve from probation?
As far as communication, there's been several attempts via email, text, phone calls, and no letters. She'll respond to the emails, but she won't give us any of the medical documentation that we requested for herself. She'll send her kids excuses for going to the doctor, but she won't send any of her own medical documentation so we can,
Why not?
Prior to, because I just had got Miss Lopez, but before that, Mr. Menard, Robert Menard, he had all of my documentation from everything from Nicholas Schuster, which is my kitty. For a fact, I know the person who dropped it off to them is in the courtroom right now, and he gave a copy to each of y'all as
Do we
well.
have that? Does the probation help?
I can look in the file and see probably.
Okay.
But
We'll look in
the
there.
most recent was, you know, we hadn't seen her since March 17th. Numerous emails, even an email.
Say that again, yes.
We haven't seen her
Oh, she absconded?
since March 17th,
Okay.
but we did get an email
You know-
from her.
You know, you had to report, and that was what you did here on proving, pleading to true to one. See, that's, if you can't do anything, if you really can't do all the other conditions for whatever reason, you have to report or else you're not on probation. You're on your own probation, and we have no supervision of you. That's why everyone has to report. That's really the most important thing. If you don't report, there's no way we can supervise.
Yes, sir.
That's the essence of probation, is supervision. And like, you may have heard of, what do you want the others? 93% success rate we have in this county for probation. So they're committed, which is greater than the national average of about 75%. The probation office I enjoy it, and it's an honor working with them because they want success. They want you to succeed. And then the moral recognition therapy. What happened on that?
Because she was sick again and she couldn't make the program. It kind of goes along with absconding. It's all kind of rolled in together. It's all part of that.
That first appointment that was going to be after I'm like for, I paid the $40 for the book or something like that. I didn't go to probation or the thing. It was going to be after that.
What should we do?
You know, I'd recommend letting her out and maybe holding this in advance for a few months, a couple months, a month, whatever. See if she can actually get her reporting. She has 8 kids, Your Honor. Her sister's in the courtroom right there in the front who's taking care of and watching the kids right now. She's going through some medical issues, missing appointments. I would, I know we've already done this before and asked you this, and you agreed to change it from deferred to regular and let her back on probation. And I know it's rare to ask the court for third chance. But that's what I'm going to do. That's for a third chance based on her medical issues. And the fact that all these are administrative violations, although like you said, if you're not moving on probation. And I understand that. And I'm not arguing against that.
Maybe I believe it's the most important thing.
I agree, Your Honor, and I understand that. But I would say that due to her medical issues, which is different than somebody just not wanting to show up, okay, or just disappearing, I think she has to know when she leaves her day, no matter what her medical condition is. One thing she has to do besides the medical appointments is go to the probation appointments. You know, the truck that is she has a medical appointment, but otherwise, do that.
What's that? Thank you.
Your Honor, I would just defer to the court. What you think is appropriate?
Probation.
Whatever the court decides.
I know that you're very polite. I know you're going to support me. I'm going to support you. But I have a bad feeling about this, the way this is coming out, because these are easy. These are really easy things to fulfill, and you're not doing it. But I'm also looking at the circumstances. Why are you here in the first place on this case? What happened?
The original case?
Yes.
In 2019, that's before I got sick. I wasn't living right. I got caught stealing the makeup to do my mom. I missed my own mom's funeral when I was in Jefferson County on January 2nd, 2019.
I know.
That day.
Yeah, that's what happens when you're in jail.
No.
Life goes by out the outside and it moves forward and without you.
Yes, sir.
You got to get on the train or it leaves. And but you shouldn't. Committing crimes is what keeps you from enjoying the blessings of liberty. Here's what I'm going to do. Anything else? I hate facts like this. This is frustrating. All right. On this motion to revoke probation, the defendant has pleaded true to allegations 1 4 and 6 of the motion to revoke probation, and has done that voluntarily, knowingly, intelligently. And the court does find that there is sufficient evidence supporting her pleas of true to grant this motion to revoke probation by a preponderance of the evidence or greater. And the motion is hereby granted, that there is enough to hereby grant this motion to revoke your probation. And earlier in this case, you had pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your plea hearing to find you guilty beyond a reasonable doubt. Now, with the evidence before the court on this motion, there is enough evidence supporting the record for me to state the following: that you allegations 1, 4, and 6 are proven true. That violates your probation. This motion is therefore granted, and you are hereby sentenced to confinement in the state jail for 2 years. But I'm not going to do that. Do you see how close you're on? I'm going to continue this motion to pend. It will pend. I will continue you on probation, but you've got to, if not for you, for the kids, everybody who needs you out there, would you please just follow? These are simple rules, and they're here to make you, to help you be the best person you can be.
Yes, sir.
Of all things, but make the best out of this, okay? Because it's real simple. Right now, this is pending. Something bad happens. You do something wrong here. It's this simple. Okay, the motion is granted. Your probation is revoked. You are hereby sentenced to 180 days up to 2 years.
Yes.
I don't want that. Nobody, too many people rely on you, right? And you're doing good things for the community. But what's the 10 Commandments? Thou shalt not steal. I mean, it's right there. It's in the good book. But this is fixable. Everybody makes mistakes. Fix it responsibly. There's a lot riding on you doing the right thing. Just not you. You're not living on this planet alone. You know that.
Yes.
Okay. Do it for yourself and for the others who depend upon you.
And Your Honor,
yes,
probation was requesting, and the state would agree that it be ordered to that she not have any mess ups whatsoever on it, just to let her know that this was kind of zero tolerance on this. She'd been given a third chance. We think it's okay, but
yeah,
you know,
it only takes one violation for anybody to revoke the probation. But it just, yeah, I don't want. I'm not going to preset any kind of violation I hear about, you're revoked. I need to hear it, and then I have to make a decision on whether it's viable or not. That's what my responsibility is, and I'm not going to prejudge. Judge not, lest ye be judged, if we're talking about the good book there. Yeah. That's a pretty important saying. Also, all persons charged with crimes are presumed innocent. That's in the Constitution too. As you made great grade on bars, you know it is. But don't let us down.
I think. Can I ask you something?
Oh boy, go ahead.
No, it's not.
Yes, I'm very generous.
Last time, whenever I think it was like a mistake, the fees rolling over or something from the first 4 years I did.
What happened now?
Like the fees, like you had rolled my fees over from.
Your fears.
It's the same.
Fees roll over. They're still there, but you are not punished if you are doing the best you can in good faith and unable to pay. We do not have debtors prison in this country. Yeah, but you do the best you can. Don't just hide the money or do the best you can. But if you're unable to pay, I can't stand even the thought of that, putting somebody in jail just because they were unable to pay and they were doing the best they could. That's not American. That's not decent. And that's not going to happen on my watch. Just do the best you can, okay? Okay. Thank you, ma'am. You're welcome. Just. Tom? Yes. You've been waiting diligently. You got Mr. McQueen and I ready. Come on up. Was it done today? I don't have it.
It's a sentencing.
Okay. It was done on another day.
Yes, sir.
Plea. What was the date on that?
June 28th.
Uh-oh, I don't have one. I got a June 23rd.
It's probably, it's probably in my queue, good answers.
I don't win July. I understand. No. 23rd.
I'm about to send it to you.
Okay. -40058, the state of Texas versus Jro McQueen. That is you, sir.
Yes, sir.
And you were here with Mr. Kelly, your attorney and the state's attorney. Previously, this would have been on June 23rd of this year. You pleaded guilty to the first degree felony of murder in this indictment. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Any corrections or changes to it? State.
Not from the state. Yes.
And defense.
So not to the pre-sentence report, Judge, but I will note, I made a mistake in our sentencing memo. I referred accidentally to the victim in the case is Mr. Brewer. Mr. Brewer was co-defendant in the case. It should have, of course, been Lee Edwards. Lee Edwards was the deceased to the indictment. That's
okay
in the memo, not in the PSR, of course, Chip. So other than that correction, no corrections or amendments.
No count, and otherwise, based upon that, the pre-sentence report is made a part of the record for all purposes. Here is a agreement is whatever sentence shall not exceed a cap of 30 years imprisonment. So we are looking at no less than 5 up to 30 years in prison. A regular probation is not an option. And the other thing would be deferred, I guess, or unadjudicated probation. Is that even an option? That's not even an option. It's all straight flat time. All right. Stand by just 1 second here. And how old were you at the date of this event?
Between
You're now 20, right? 20 years of age now?
Yes, sir.
Okay. I have something from an Ashley Butler. Is she your grandmother? She calls herself your nanny, but your aunt.
There is a letter from Miss Nancy Wilson, Judge, that's Mr. Policeman. Should be included.
There is Renata Mascara wrote something on your behalf. How is she related to you, or how do you know her? Miss Renata Mascana?
No, I need your grandmother.
Okay. And there's a letter from Latoya Charles. How is she related to you?
That's my godmother.
Your godmother. All right. State, do you wish to go first? You can go first and last.
Judge, this case originally had two people charged. There was an Isaiah Brewer and Mr. McQueen were charged. This was supposed to be just a group of people meeting for a fist fight. And as usual, when a fist fight is about to start, somebody pulls out guns. In this case, the question was always been whether or not there was a self-defense because the defendant has claimed and still claims today in his pre-sentence report that the victim pulled a gun and pointed it at him and his family. And so he was just defending his family. But the reason that I think he pled is because when we came up for trial, the co-defendant had agreed to testify and was going to testify to the fact that the statement he gave the police was that the victim, while the victim did have a gun, the victim never pointed it at the defendant or any of the family members. And there was also another sister of the defendant, I believe, or a witness that was with the group of the defendant who also would testify that a gun was never pointed at the defendant or any of the family members. That the minute the argument started, the co-defendant said that the victim had pulled out a gun to point it up in the air to make everybody get away. And that's when Mr. Jro McQueen started shooting and shot about, I forget how many bullets there were fired, but pretty much unloaded his gun, shooting the victim. The victim, when he was falling down, then returned fire to shoot back at them, hitting a car, and then did not wound anyone that I know of. This was, once again, one of those shootouts that we have in Beaumont where, unfortunately, someone got killed. And it's all these youngsters running around with guns. And this one, I don't understand why they had to go meet up at the victims across from the victim's sister's house. The victim's sister claims that they were chasing her brother and were going to gun him down, and that he never stood a chance, that she heard the shots. She came outside and they were driving away and still shooting out the back of the car. So all this adds up to, we do know that Mr. McQueen when the police arrested him, he did admit that he's the one that shot and killed the victim. I've given him credit for that admission for at least owning up to it. And also because there was some other activity out there that was fighting and I capped it at 30. I think that looking at his history, not only his prior juvenile history, but looking at his history since he's been in jail, you've got a copy, I think, of all the jail incidents. And he hasn't really shown that even if he was wanting to straighten out his life or try to convince the court that he was very remorseful for what he did, his incidents in jail show that he just has no respect for anything or anyone. And so we would ask for the 30 years.
All right, Mr. Kelly.
Thank you, Your Honor. Number of things that are important in this PSI. None, and Mr. Riley, who I think is in the courtroom today, judges who composed this for us for the court. But one of the things that stands out maybe a little bit more than the others is at the beginning of Mr. McQueen's social and personal history, which of course is on page 4 of the It's the second line. I know the court has seen this already, that Al's dad was Jro McQueen Sr. and that he left this earth in 2017. My math is right. Al was 12 at the time when he lost his dad. And I've thought about that through the course of this case, and certainly since we got this.
What year was that?
2017.
Okay.
And more.
What was the date? March 7th, you said? What was the date he lost his dad?
2017. The month is not
okay.
Included. And I've thought about it more since we got this report. Maybe not fair to put myself in his shoes, but as a human being, you can't help that. And to think that when I was 12, my dad was my hero. And to wonder what your life looks like had you been born into different circumstances or had different circumstances. And it's not a completely apt comparison, but hopefully those of us that deal with these hard cases in here every day can at least have an awareness of that. And one of the reasons that it's important is that the court has looked at the pages before that, and Mr. Lair is correct. And he notes some of the issues that Al had as a juvenile, and they line up with those same dates. That's where this thing kind of got off the rails a little bit. And I know that Mr. Laird and I have that conversation. The court says it on the record a ton, and whether you want to call it science, whatever it is, those two things go together. There's zero question about that. Those two things go together, and those events, Mr. McQueen Sr. leaving the earth and the beginning of these issues are right there. And they're not excuses. And Al's going to talk in a minute. They're not excuses, but if we're going to say that a pre-sentence report is at least more than a snapshot of a background, then we have to be fair enough to take those things into account. One of the other things that we mentioned, and the court looked at our letters that are included in our memo to the court, but one of the other things that we mentioned is it's not to devalue anything, but this is, and again, I think Mr. Laird said it exactly accurately. It is tragic in the classical sense that life could be treated in such a way. And one of the questions that this court asks more often than it probably wants to is, how do you bring a life back? And you can't. And so then the question becomes, what is just, what is appropriate for that family, for the Edwards family, but also Al's the one standing in front of the court. So what then is appropriate for him to have accepted responsibility? To have, I would say, supposedly saved a number of different folks. The a trial, which would only be a rehearing of those facts of that day. And some of those folks are here today. Some are Al's family members and some are other folks. But what then is appropriate? I can't tell what is more disheartening as somebody that, again, for all of us that work on these kind of cases every day, what's more disheartening is the case where you look backwards and you see a number of criminal episodes that of course culminate in a murder, and we all look at each other and say, well, that story wrote itself. Or somebody who hasn't even started life yet and is here already. Not excuses, but they paint the rest of the picture and they have to be accounted for. I know that the state's position is that some of the credit is in the cap, and I don't disagree with that. We ask the court to take into account everything that we've put into that memo. The folks that wrote letters on his behalf to the court, I can't imagine the angst that it causes a mother and a grandmother to have to write a letter to a court in this situation. I think in the same way that the Edwards family has been dealing with loss for the last 3 years. So too will these folks, in a different way and less permanent. Wouldn't compare those two things. They are facts, but both of those things can be true. So we ask the court today, in light of all that, for measure of leniency around that the court will allow, that he will address the court too.
Go ahead.
Your Honor, I am sorry. I do apologize for the crime that I committed, but I am not pleading guilty because of someone wanting to testify. It is not scary. I'm pleading guilty because I know I was wrong and that I could have handled the situation different.
Go ahead.
I'm asking for not for the 30, not only for me, but for my family too. I understand what I did was not right. But I can't change someone else's mind if I wasn't out of the situation. I mean, I did probably what anybody else would do if their family was in a situation like that. What was
Go ahead.
I'm done.
Thank you, Judge.
He's got a funny way of showing how sorry he is by the way he's acting in jail. Totally disrespecting people, not following rules and just wanting it his way. And I think that's been his life. When you look at him, all of his juvenile history, it's the way that when he gets in trouble, he gets probation and then he messes up. He violates the court order several times on just a misdemeanor criminal trespassers. There's 1, 2, 3, 4, 5 violations, and that one just in 2018. And he gets probation again for another. He's got more violations, and he gets a terroristic threat. He's got more violations, and all he does is he just does it his way, and then thinks saying "I'm sorry" is okay, and it's not. You got somebody that's deceased that's not coming back. By his making a bad decision was not a bad decision. It was a terrible, horrible crime that he committed. So he would ask for the 30.
How old was Mr. Edwards at the time of his death?
I think he was.
Yeah.
He was about to something things.
This is born in 88.
Yes, Joseph said you.
I'm sorry.
12 and 25, 37.
There's great. Time.
But when this happened, in 22, so it would have been 33 or 34. Okay. Anything else by anybody?
No, Judge.
And the state is asking for
The 30.
all right. In the pre-sentence report that has been admitted into evidence here, the court has reviewed that, and an important thing here, Mr. McQueen, that we all try to use as a test and a determination in what goes on here. Punishment generally is based upon criminal history and the circumstances of the crime. Also, the court looks at the person's environment, their lifestyle, their choices that they have made in their life. And all of those are compiled very well in a pre-sentence report that the probation office fixes up. And here we have you have a juvenile history that begins in 2017 with being a runaway, then criminal trespass, robbery, runaway, criminal trespass crimes, terroristic threat, criminal trespass, theft, unauthorized use of a motor vehicle. All of these are, even through 2020, unauthorized use of a motor, evading arrest or detention. Several pages. And then this event occurs on May 28th when you're 17. And the pre-sentence report also states that not only do you have a consistent commission of crimes and illegal acts, but those also include you're smoking an average of 5 marijuana cigars a day. This says from the day from 16 years of age until May 28th, when this event happens. I mean, daily. So you're making bad choices all the way around. Plus you're high as a kite consistently. So we have the shooting to death of a person. a large juvenile criminal history. There were inconsistencies in your accounts when you were talking to law enforcement and the investigators about what happened here. This was a shooting that occurred from a plan to meet with people to air out grievances in a way that wasn't going to be using, I thought, and a peaceful means. Everybody seems to have a gun. And everybody you certainly, according to this report, it suggests that you had planned to use a gun. And this doesn't show anything spontaneous. And the self-defense claim is undermined right and left by the facts that are shown in the reports. Then, after this happens, you dispose of your cell phone, clothing, things that you're doing to avoid detection and to try to prevent the trail of the event leading to you, which is consciousness of guilt. And you're placed in jail. How many write-ups have you had for jail behavior problems? I'm going to give you a hint. I'm looking at over 30 pages. I've never seen such a thing by anyone before me with that many jail pages of jail problems. But the way you handled all of this while you were waiting is as irresponsible as you handled the event. It shows such a lack of remorse. But it's as though you don't want to do the right thing. Do you know how many write-ups you've had? 55. I've never seen that many here in 18 and a half years. Yeah. Isn't good. It isn't good. And here you are at 17 and you're taking a life. I've read some letters on your behalf from, it looks like families and acquaintances. What they say about you, though, is completely different than what this report shows, which are the bad things. You can't be Dr. Jekyll and Mr. Hyde. You can't live, you can, but it's like dancing on a razor blade. It's not safe and it always leads to destruction. But you can't be good and bad. You got to make a choice. Your choices have to be good. This was tragic. And now, with all of this, we have a life that was lost that you took, that you're going to have to carry the rest of your life. But I don't read anything here at the end. I don't hear anything about, I'm sorry this happened. I don't see it anywhere. I guess I'm not surprised, but I don't see it at all. And really, you're admitting you did this and somebody was killed and a life was taken. One of God's creatures was taken, but it's not much of regret. No sign of it whatsoever. Certainly, you hadn't shown that you wanted to make the right choices since you've been in jail. And Mr. Kelly is a great lawyer and is trying hard, but it's hard. It's hard to manufacture help for you when you're not wanting to help yourself by making the right decisions. And then here we are. And the probation office kind of sums it up in the probation the report. That any factors of leniency are may be outweighed by the gravity of the murder, your extensive juvenile record, your ongoing behavioral issues in jail, and the actions surrounding the crime which indicate consciousness of guilt. And the court should consider these factors as well as others presented by the parties. And you were looking at up to life in prison, which I can't even imagine for a 17-year-old. But anything else to add by anybody? No. Or anything, Mr. McQueen, you want to say? No. No. All right, I am going to follow this agreement, and that he will be sentenced within this agreement frame. Jro McQueen, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this case to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in this case. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 30 years imprisonment as agreed as the cap in this case. You will be given credit for all time you have served. And the judgment shall reflect that a deadly weapon, mainly a firearm, was used in the commission of the offense. You have a right to appeal all, well, he's given up his right because we followed the agreement. So you were unable to appeal this, but you will be given credit for all time you've served in this. Is there anything else we need to touch base with in this sentence? Anything? All right. Good luck to you, and I hope you live better. That is all on that case. Yes, Don.
Please, Your Honor.
Come on, come on out.
Well, seriously, Landry.
Yeah. Who is it first?
Carlos Landry.
Okay. It is 24 CR 2098. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
Sure. Summary. This indictment alleges that on or about September 9th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you are charged with? If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
The agreement's been reached. You'll be pleading guilty, sentenced to 4 years in prison, given credit for all time served. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it, discuss it with your attorney or the contents correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. The state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. It's been read to you. You've read it. You were guilty of the crime chose and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All truth so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report is waived.
Yes.
I will follow this agreement if nothing further. And find, sir, you were pleading guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention of a motor vehicle. I am following this agreement to deliver my sentence to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You'll be given credit for all time you have served in accordance with this. Anything else?
No, sir.
That is all. Thank you.
Yes, Ron.
Don on Shoemaker.
Yes, sir. We've got pleas on 7 state jail felony motions to revoke. And then we're going to hold the other 3 cases, which is a third degree motion to revoke and 2 new cases. We're going to reset those for further discussion with state. On 7, they're ready to go.
Okay.
Do you want to go through those today?
Yeah.
Or
Yes. And they're all state jail felonies, 2 years state jail.
okay, what are the numbers, please?
Okay. Their number 41005.
Hold on. There. Okay.
107.
Okay.
109.
Okay.
111. 113.
Okay.
115. And then 40705.
So we then are going to reset 25 CR 858, 25 CR 859, and 25 CR, I'm sorry, 22-40954.
That's correct.
Is that right? Okay.
How long are we setting that?
4 weeks.
So are we setting it for hearing on this?
No, we're gonna deal on the rest of it.
Announcement on those 3.
Okay, understand.
Yes.
Thanks, Dustin. Recording.
Yes.
You're Mr. Shoemaker?
Yes, sir.
Okay. Here with your attorney, Mr. Dusler, and this state's attorney. You're going to be pleading true to some motions to revoke probation in clause numbers 22-40705, 41105, 41107, 41109, 41111, 41113, and 41115. Raise your right hand. Do you solemnly swear or affirm any statement you make during these hearings with the truth, the whole truth, and nothing but the truth, so help you God? Lower your. Does the defendant waive formal readings of these motions to revoke probation? Here. That's, no, leave that up here. You'll take this, I'm gonna knock it off.
Oh,
Because I'm gonna have to spread all these out.
okay, yes.
Yes, sir. He waives formal reading of the motions in each of those 7 cases.
Five, 6, 7. In summary, and he waives formal readings, we can go in summary?
Yes.
In summary, sir, each of these motions to revoke similarly state that on April 10th, 2023, in this court, you were sentenced to 2 years in the state jail, probated for 5 years for each of these 7 cases that we called the numbers for. And you were in 22-40705, you were convicted of forgery of a financial institution, sentenced to 2 years in the state jail, probated for 5 years. In 41105, securing the execution of a document by deception, a state jail, and sentenced to the same 2 years in prison, in state jail, probated for 5. In 41107, the state jail felony of theft, 2 years, convicted in the state jail, probated for 5 years. In 41109, forgery, a state jail felony, and the same sentence. In 41111, 2 years in the state jail, probated for 5 years for securing the execution of a document by deception. In 41113, again, the same sentence for forgery of a financial instrument, a state jail felony. And finally, in 41115, you were sentenced to 2 years in the state jail, probated for 5 years for the state jail felony of theft. All of that on the same date, April 10th, 2023. All of that true and correct, sir.
Yes, sir.
All right.
You can count one sufficient.
Allegation 1, and is this the same allegation in every motion?
Yes, sir.
I'm hopefully so. So I'm on.
You don't know?
I believe so.
I believe they
I
are.
believe so. It's not. Each of these 7 motions to revoke probation that have been filed in these 7 cases similarly allege in allegation 1 in each case that you committed the offense of illegal possession of a controlled substance on or about March 10th, 2025 in Hardin County, Texas, in violation of condition 1 of your probation order. Stand by. And this was cocaine. Is all of that true and correct?
True.
All right. Are you pleading true in each of these cases to allegation one of these motions to revoke probation voluntarily, knowingly, and intelligently, and because those are true as they are alleged?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can now be revoked as you were on regular probation in each of these cases for 5 years, and you can be sentenced to no less than 180 days up to 2 years in the state jail in these cases. Knowing that, do you insist on pleading true today, sir?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. In each of these cases, the agreements are your probation would be revoked. You would be sentenced to 2 years on the state jail in each of these cases. And these would all run concurrently with each other, all 7. Is that your understanding of the agreement?
Yes, sir.
If I follow these agreements in each of these cases, you have no right of appeal of your cases. Do you understand?
Yes, sir.
I'll show you what's marked as States Exhibit 1 in each of these cases. Did you sign those documents voluntarily, understand them, discuss them with your attorney? Is everything true and correct?
Yes, sir.
Sorry, States Exhibit 1. States Exhibit 1 is tendered into evidence without objection.
No objection.
Admitted. Among other things, this states you are waiving all rights of appeal if I follow these agreements, which I intend to do. Do you understand?
Yes.
And again, you under oath are pleading guilty to illegally and knowing voluntarily, intentionally and knowingly possessing cocaine on or about March 10th, 2025 in Hardin County, Texas, which you know is a violation of condition 1 of your probation order, which is do not commit an offense.
Yes.
And you are pleading true to that again, voluntarily, knowingly, intelligently, and because that is true.
Yes.
I'm going to follow these agreements. Anything else to add?
No, sir.
And you're pleading true in each of these 7 cases. And is that true?
Yes.
To the same allegation in the motion to revoke probation? All right. Then in cause numbers 22-40705, 41105, 41107, 41109, 41111, 41113, and finally 41115. I find that there is sufficient evidence supporting the motions to revoke probation to grant each of them by a preponderance of the evidence or greater as allegation 1 has been proven true, that the defendant committed the offense of illegal possession of a controlled substance, namely cocaine, on or about March 10th, 2025 in Hardin County, Texas, which is in violation of condition 1 of his probation order. Thus, in each that is found true in each of these 7 cases. Thus, the motions to revoke probation are hereby granted, and the defendant's probation is hereby revoked by a preponderance of the evidence standard or greater. I'm going to follow these agreements if nothing further. And find you or here, your probations are revoked in each of these cases. And you were hereby sentenced to confinement in the state jail for a sentence of 2 years on each of these 7 cases. And these sentences shall run concurrently with each other. You will be given credit for all time you have served in accordance with these cases. Do you understand what has happened today, sir?
Yes, sir.
Anything else?
No, sir, not today. We'll get back to the court on those other cases.
Okay.
Thank you.
Well, just one more probation revocation, but I'm gonna work it out with the other. I can bring the section all the time. And this is,
Won't have to do anything. You'll just have to show up.
Docket's fine. Then we'll do this. Looks like you have 3 people left, Judge.
Okay. Jeff, Marcus,
Yeah. Oh.
This is all withdrawal motion.
Okay, Mike, you have ready to go with the same report. Thank you. I've got that.
thank you. Policy.
It's fine. If you just start this.
Okay. Have Adrian, is it Adrian Ball?
Yes.
Adrian, where's?
He's in custody. I'll need to,
Fingerprint.
and fingerprint him. Yes.
Then I have, well, I have 2 cases on Adrian.
You
3.
step forward.
I have 4. I do have 4. What are we gonna do? He's pleading to 1433.
He's pleading to 3 of them. 5-5 is being this.
No, 5-5 was a reindictment.
Come on up.
Pleading to 3-6, 3-4, 3-3. And then dismissal of 3-5.
I got another document match in this. Place right. Okay, go stand for the judge.
All right, John. 4 cases are call 23 CR 1433, 1434, and 1436. You will be entering pleas of guilty to those indictments. And then there is a 1435, which will a different charge, a second-degree felony, which will be dismissed. Is that your understanding?
Yes, sir.
All right. You were here with your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yeah, sure.
Oh, this was off the trial.
Yes.
Where else? There. Number 5. Okay, again, Mr. Wilkerson is here representing you. In summary, sir, and can we? All of these allege the same crime, correct?
2 of them allege a child less than 6, and 1 of them alleges a child less than 14. So they have the same crime, but they have different punishment levels.
Okay, so 2 are younger than 6.
Yes.
1 younger than 14.
Yes.
All right, in 23 CR 1433 and 1434, Mr. Ball, these indictments allege that on or about February 1st, 2023, and on or about September 1st, 2022, respectively, in these 1433 and 1434 indictments, it is alleged that you committed the 1st-degree felonies of aggravated sexual assault of a child. Do you understand what you were charged with in those 2?
Yes, sir.
Okay, and for these 2, the punishment range is not less than 25 years, up to 99 years or life imprisonment.
Yes.
Is that your understanding of the punishment range?
Yes, sir.
In these 2 cases, agreements have been reached where you would be pleading guilty sentenced to 30 years in prison to run concurrently with each other. Is that your understanding? Each other and also the third case of 1436.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case in this case. Do you understand?
Yes, sir.
How do you plead in this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
And because you are guilty? Yes?
Yes, sir.
Okay. And again, in 1434, you are facing the same punishment range on or of and this indictment alleges on or about September 1st, 2022, you committed the first degree felony of aggravated assault of a child younger than 6 years of age. And again, the same punishment range, no less than 25 years up to 99 years or life imprisonment. And the agreed sentence is 30 years in prison to run concurrently with other cases. Is that your understanding?
Sir.
If I follow these agreements, you have no right of appeal.
Sir.
How do you plead on this case? Guilty or not guilty?
Guilty.
You're pleading guilty voluntarily.
Yes, sir.
And because you are guilty.
Yes, sir.
Finally, in 23 CO 1436, this alleges on or about May 19th, 2018, in Jefferson County, Texas, you committed the first degree felony of aggravated sexual assault of a child who was then younger than 14 years of age. Do you understand what you're charged with?
Yes, sir.
You're facing a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000 in this case. Is there also a fine in the others?
No, Your Honor.
They're not because it's a super aggravated. So do you understand the punishment range in this case is again 5 to 99 years or life imprisonment and a fine up to $10,000?
Yes, sir.
And an agreement has been reached. In your case, you would be pleading guilty and there is nothing here.
It's 30 years to run concurrent with the other cases.
Okay. To run 30 years in prison to run concurrently with the other cases. Is that your understanding of the agreement as well in this case?
Yes, sir.
If I follow this agreement, you have no right of appeal of
Yes, sir.
This case as well as the others. I'll show you what's marked as State's Exhibit 1 in each of these cases. Did you sign those documents voluntarily, understand them, discuss them with your attorney? Is everything true and correct?
Yes, sir.
State's Exhibit 1 in each of these cases tendered without objection?
No objection.
Admitted. A State's Exhibit 1 in each case states this, sir, that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and totally satisfied with the representation provided by your lawyer. All of this is true. It states in each of these cases, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes without objection.
Without objection.
Without objection, it is admitted. Pre-sentence reports are waived.
Yes.
If nothing further to add, I'm going to follow these agreements, sir. And find in each of these cases, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea in each case from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these first-degree felonies of aggravated sexual assault of a child that you have pleaded guilty to this morning. I am finding you guilty beyond a reasonable doubt in each case. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 30 years in each of these cases that shall run concurrently. And do you understand that you are now required to report under the sex offender reporting laws of the state of Texas? You're going to have to do that for life. And failure to properly register regularly can result in a felony offense, and you could be prosecuted. So it's very important that you understand your requirements and you follow those. Do you understand, sir?
Yes, sir.
Anything else to add on these cases?
Judge, I would just note for the record that the agreement also involved dismissal of 23 DCCR 1435.
Okay, I have that in my hand. When the motion is presented, I will sign. Anything else to add on these?
No,
That is not. Thank you. We're in recess on these cases. Thanks.
Thank you. So, stuff. Let me give me the jury around this one.
What are you looking for?
Sex offender.
Oh, sorry, get a small good way.
So, honors. This is just.
Yeah, I'll need a dismissal motion in that 1435.
Oh, it might be.
It's working its way. The next is who?
Jason Smith.
Jason Smith.
Mr. Kimler.
Okay. 23 CR 1435, motion to dismiss on Adrian Ball is before the court. It is signed. The case is dismissed as part of the agreement.
Pretty good. You good, maybe? No, position that make it.
It's on here.
You don't need period of administrative. It's straight probation.
All right, we now call two matters involving Jason Smith. You're Jason Smith?
Yes, sir.
And with Mr. Kidler, your attorney, and the state's attorney will be here. I am 28788 and 29417. These motions have been filed. Dustin, the defendant waive formal readings of these, and we proceed in summary.
He does remain.
Each of these were filed on July 21st, 2025. The defendant waive any additional time under the law he may have before disposing of these cases. Can we move forward? I guess these were filed on July 21st.
Wait,
11.
Wait, 2 minutes, fine.
Judge, we're going to need to have a hearing because he's not going to plead guilty to or through to count one.
He's prepared to enter pleas and treat him to administrative violations. I believe those are community service and fees, and then not true in the other involved.
State's only concerned about the new charge, Judge.
And he's on, I believe, 10 over 10 in both cases. We were going to request a bond.
No. There's a deferred 10 years on this one.
It's deferred on
one.
And then 10 over 10 on the other.
Yes, Judge.
It's a second degree felony on the aggravated.
On both are second degree.
Okay, so we don't have an agreement?
No, sir.
Okay. Are you ready to move forward on?
We were going to plead free to the administrative and not treat it.
the big case, and then we'll have to have a. He tells me that this morning when it was added on docket, Judge. It's set to be indicted on, it's appearing before the grand jury on Wednesday. Mistaken that.
I don't mean to add anything around this. Since Mr. Smith was originally the client, but he was arrested on the new charge. Now, it was my understanding from the detective in the case, Detective Carmouche, that this was being indicted federally. However, it's my understanding from Mr. Kimler that that may not be the case, although there has been an article already published indicating that he and his co-defendant were indicted in that case. And so I don't know if there's a matter
in what, federally or the state?
That new case that I believe Mr. Ham is referencing.
I checked, he might be, Your Honor. I checked at the jail. There is a federal detainer. That's the extent of my investigation. He added this case today. I have no chance to check it all out and determine any of that.
What do you want me to do today? If they're not ready.
He's trying to get a bond. I want to have a hearing on the new charge because that's what concerns me. Which is fine. We can do that. Let's have a hearing. Otherwise he's sitting in jail. We need to get it disposed of, Your Honor. So they'll plead true to the community service and fees, not true to the ad valorem, and set it for a hearing.
All right. Does the defendant waive formal readings of these motions to revoke probation and unadjudicated probation respectively? Clause numbers 18-28788 and 18-29417. Can we proceed in summary?
Yes, sir.
In summary, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, 18-28788 states that on June 21st, 2019, in this court, you were found guilty, sentenced to 8 years in prison, probated for 10 years for the second degree felony of illegal possession of a controlled substance.